So my co-anchor Suhas, we both are pursuing our LLM from Gujarat Maritime University. Yesterday, we set sail with some truly rich insights in evolving dimensions of ocean's law and policy. Today, we continue that voyage, charting new waters with discussions that promise to be just as deep, dynamic, and engaging. And every good voyage needs a skilled navigator to guide us through today's proceedings. I am delighted to introduce our Master of Ceremony, Dr. Abhay Singh Thakur. Dr. Thakur serves as an assistant professor at Gujarat Maritime University, where he is also director in charge of School of Maritime Law, Policy and Administration, a member of the Board of Management, and head of the Center of Maritime Environmental Law. So without any further delay, I now invite Dr. Singh to provide the essential housekeeping remarks.
Yes, good morning, everyone. Welcome to the last day of the COLP. So I'll just quickly give you a brief overview of the housekeeping remarks, since many of you were there already yesterday, so it will not be a news for you, but just a kind reminder. So the time allocated for each speaker during the different panels is 15 minutes. So it is urged that you don't cross the 15 minutes mark, and it is also urged from the moderators to ensure that speakers are not going beyond the 15 minutes mark. Furthermore, all the Q&As will be held in the end of the session. We have kept 15 to 20 minutes for the question and answer. And after the floor is open, I ask everyone to keep their questions for the end. You can note down your questions on the notepad, which is in front of you, in case you have any question in between, so that you can ask it after the session is over. So all the questions will happen after the end of at the end of each panel. So I also request everyone to keep their phones on silent, so that we don't disturb during the proceedings, during the ongoing proceedings. And in case you want to step out, I will urge you to step out in a silent fashion as not to disturb others. That's all from my end. Thank you so much for your cooperation, engagement, and we look forward for the insightful sessions coming our way. Thank you so much.
Thank you, sir, for taking the helm for today's proceedings. As we begin with the third day of this conference, it's my privilege to welcome Professor James Kraska, Chair for the Stockton Center for the International Law in the U.S. Naval War College. He is a distinguished scholar and expert in the international maritime law with an extensive career including roles as a visiting professor at the Harvard Law School and Gujarat National Law University. He has authored numerous influential publications on the law of the sea and naval warfare. Professor James Kraska will be joining us through online. The rapporteur for this session will be Rahul Desarda, Assistant Lecturer at Jindal Global Law School. I invite Professor James Kraska to deliver the welcome address and offer reflection on the progress and key takeaways from the conference. Please join me in warmly welcoming Professor James Kraska.
Good morning, distinguished colleagues, scholars, and friends. It's a great honor to welcome you to the third day of the 48th Conference on Oceans, Law, and Policy. Indeed, likely the most consequential academic conference on the law of the sea and maritime policy in the world. I hope that yesterday's discussions inspired new ideas, deepened old friendships, and spark future collaborations. This is really a coalition effort. I'd like to recognize our important partners, beginning first with our wonderful host, Gujarat Maritime University, as well as stalwart supporters for many years, Ronan Long at World Maritime University, and indeed there are a dozen other conference sponsors, including some who have hosted the conference in the past: Korea Maritime Institute, Japan Institute of International Affairs, and the Nippon Foundation in Tokyo, the National Center for the Sea and Maritime Law, DHUKAM in Istanbul and Ankara. And we also have numerous other partners: IMO IMLI, the University of Copenhagen Faculty of Law and the Climate Center there. And we're very proud to be able to develop this network and share this journey in understanding and building the rule of law at sea. We're beneficiaries of the investment of these institutions and their interest in oceans law and policy. Also, I'd like to thank the some 70 or so speakers, moderators, and rapporteurs that are sharing their ideas and will help us to capture them for future generations, future people that can harvest the ideas that we're producing. I'd like to share, just by background, a little bit about the Stockton Center for International Law at the United States Naval War College. We have the privilege of serving as the continuing steward of the Conference on Oceans Law and Policy. For us, this conference embodies a tradition of dialogue and scholarship on some of the most consequential issues facing the global maritime community, with legal and policy implications for governance of the oceans that shape our common future. The Naval War College was founded in Newport, Rhode Island in 1884. It's the world's oldest naval war college. And when the institution was established, it had only 2 courses. The first course was on naval operational art. The second course at its founding was on international law, because international law is so fundamental to stability, security throughout the oceans. Today, that legacy continues in the Stockton Center, where we engage with scholars, practitioners, and officials in governments and non-governmental organizations, diplomats worldwide, on some of the most pressing issues in international law and the law of the sea, as well as in emerging domains such as cyberspace and outer space, or in the complex intersection between security and stability and the rule of law in artificial intelligence, autonomous vehicles and vessels, and even biosecurity. We also have been partners with our colleagues in India, especially working with Bimal Patel and Dr. Shantakumar. We have spent time at Gujarat National Law University, Maharashtra National Law University, with other institutions such as Observer Research Foundation, National Maritime Foundation, Indian Society of International Law, the Indian Supreme Court, and even had the privilege of briefing the National Security Council and National Security Advisor 2 times. I'll also note that my colleague Sanjit Ruhal sponsored, and we participated in, the first workshop on the subject of national security law in India when he was on the faculty of Symbiosis Law School in Pune. One of our most important contributions from the Stockton Center is the publication of International Law Studies, which holds the distinction of being the oldest journal of international law in the United States. Over the past 5 years, articles in the journal have been downloaded 1.5 million times by readers from more than 230 nations and territories around the globe. We're especially pleased that among the top 10 nations downloading international law studies scholarship are India, Japan, the Philippines, some European countries, and even in the top 10, China. So we're very happy that we're reaching all of the influential scholars and decision makers for the most important part of the globe. We also publish manuals and treatises that have become global reference points in the field of oceans governance and maritime law, including the Commander's Handbook on the Law of Naval Operations, which is an official U.S. Navy, U.S. Coast Guard, and U.S. Marine Corps publication. We have supplemented that with scholarly works such as the Newport Manual on the Law of Naval Warfare. This is a restatement governing the rules for conflict at sea, and we're very pleased that Captain Gurpreet Khurana of India was one of the contributors. That publication has been downloaded more than 16,000 times. We also have participated in the crafting of the Tallinn Manual applicable to law of cyber operations. And together, these and other publications dealing with outer space, artificial intelligence, are shaping how states and international organizations and scholars understand and apply international law in peace, during crisis, and in conflict. So we're very pleased to work with these wonderful institutions and continue our mission as a hub for dialogue and collaboration, to engage with governments and non-governmental organizations and international organizations and academic partners worldwide. And we're no more happier than to be able to work with our host, Gujarat Maritime University, and the associated Gujarat National Law University, and with Dr. Shantakumar. This spirit of open exchange that is prevalent in GMU and GNLU, and that is fostered by Dr. Shantakumar and before him by Bimal Patel, is at the very heart of the Conference on Oceans Law and Policy. It's within this tradition of scholarship and openness that COLP has thrived for almost 5 decades now. We are proud to stand on the shoulders of the mentors that have come before us, including giant figures like Satyanandan, John Norton Moore, and Myra Nordquist, who began the Conference on Oceans Law and Policy decades ago. It's been hosted by Ronan Long in Ireland. It's been in Russia, Sweden. They took it to Norway and Singapore with the Center for International Law, Nilofer Orl and Bob Beckman. We've also been in Indonesia, hosted by Ambassador Havas, who is, we're happy to say, is with the conference. Also in Korea with the Korea Maritime Institute, and with Shanghai, with the Ministry of Foreign Affairs in China, in Shanghai, and also Beijing, 2 countries in 2 cities in China, with the Ministry of Foreign Affairs. Since we inherited the Conference on Oceans Law and Policy, we are proud to have taken it to Malaysia with the Malaysia Institute of Maritime Affairs, with Tokyo, Sasakawa Peace Foundation, the Nippon Foundation, the Japan Institute of International Affairs, Istanbul, the Ministry of Foreign Affairs in Lima, and now the grand global city of Delhi. So as we continue the sessions, I encourage all of you to embrace the spirit of engagement that has defined this conference for nearly half a century. Be bold in your questions, generous in your listening, and creative in your search for common ground to develop the rule of law and oceans governance. The oceans connect us all. They sustain our economies, our security, and the health of our planet. The work we do here in dialogue, in scholarship that will follow, matters not only within our disciplines, but far beyond this room and in other disciplines and in the halls of governance. So on behalf of the Stockton Center for International Law and the United States Naval War College, I thank you sincerely for your participation participation, and I hope that the third day is as fulfilling as what has come before. Thank you so much.
Thank you, Professor Kraska, for that wonderful, thoughtful recap and setting the stage for today's sessions. Now we have session 5, which is a parallel session. Kindly note that session 5B will be in the conference hall 1 and session 5A will be in the conference hall 2.
Good morning, everyone. Today, we are diving into some of the most pressing legal and security challenges on the high seas. And to navigate these complex waters, we need a steady hand at the helm. We are honored to have our moderator, Commander Chris Hutton, Judge Advocate General Corps, United States Navy, and a distinguished member of the Stockton Center for the International Law at the U.S. Naval War College. Commander Hutton brings extensive expertise in international maritime law and operational legal issues to moderate today's important sessions. And he is joined by an exceptional panel, each bringing a vital perspective from a different corner of the globe. First, we'll journey to Northeast Asia with Dr. Young Kil Park, Research Fellow at Korea Maritime University. His current work focuses on the law of the seas issue in East Asia, such as maritime delimitation, territorial disputes, and development of the continental shelf. Next, broadening our focus, we have Dita Liliansa, a distinguished research fellow at the Center for International Law at the National University of Singapore since 2018. In addition to her role at the university, she serves as a nominated member of the International Law Association Committee on the Protection of People at Sea. And finally, we have Professor Dr. Adamini Odeke, Special Advisor and Leading Researcher at Ankara University, National Center for the Sea and Maritime Law. His extensive career is marked by prestigious appointments, including served as a Fulbright Lloyds of London Insurance Scholar, a legal consultant at the United Nations Secretariat, and holding numerous visiting professorships at universities worldwide. It is a pleasure to introduce our rapporteur, Dominic Virgil, Foreign Service Officer, Directorate of Legal Affairs and Territorial Treaties, Ministry of Foreign Affairs of the Republic of Indonesia. The stage is set for a truly fascinating and wide-ranging discussion. Please join me in giving a very warm welcome to our moderator, Commander Chris Hutton, and our panelist speakers. Apologies. It is a pleasure to introduce our rapporteur for this session, Ms. Insha Babu, an emerging legal scholar from Rajiv Gandhi National Law University. It is particularly fitting that a sharp mind from one of the nation's premier law schools is chronicling our work today. We are grateful for her dedication to this vital task. Thank you.
Thank you very much. Good morning, everyone. It is my privilege to moderate this important panel on maritime security, a theme that has come up throughout our discussions at COLP and remains central to the effectiveness of all maritime regimes and laws. This is because maritime security is not simply one issue among many. Without secure seas, the rules we craft cannot function, prosperity cannot take root, and the very interconnectedness that brings us together would begin to unravel. In short, security at sea is what makes cooperation, governance, and stability possible. The panel today will speak to a variety of critical topics affecting maritime security, not just in the Indian Ocean, but across the globe. Each of our distinguished speakers will have 15 minutes for their presentation. To help us stay on track, I will ring a bell at the 12-minute mark, and as a gentle reminder, again, when there's 1 minute left. We'll hear from each speaker in turn and then move to a 25-minute question and answer session with the audience. Our first presenter is Dr. Young Kil Park. Dr. Park, the floor is yours.
Good morning, everyone. It is a great honor and pleasure to speak at the 48th Conference on Oceans Law and Policy here in Delhi. I sincerely thank the organizers, especially Gujarat Maritime University, for their invaluable efforts in making this conference a success. This morning, I would like to discuss China's declaration of no-sail zone in the Yellow Sea in May of this year from the perspective of the international law of the sea. This declaration drew significant attention in the Korean media and raised concerns within the Korean government, as it may be viewed in the broad context of China's gray zone tactics and the expansion of its maritime presence in the Yellow Sea. In May this year, China declared 3 no-sail zones in the Yellow Sea, effective from 22 to 27 May this year. 2 zones were designated for military exercises, and the purpose of the southernmost zone remains unclear. In response to the designation of this no-sail zone by China, the Korean government expressed concern that such designations could excessively restrict the freedom of navigation. In the past, China has typically designated no-sail zones effective for only a few hours, often in connection with military exercises, such as missile tests. Let's see some factual backgrounds before examining the legal questions. The EEZs of Korea and China overlap in the Yellow Sea because the distance between the coastlines are less than 400 nautical miles. The provisional maritime zone established under the 2000 Korea-China Fishery Agreement applies the principle of flag state control, but it is limited solely to fisheries. Korea seeks to exercise jurisdiction up to the provisional median line in accordance with its EEZ and the Continental Shelf Act. China, by contrast, claims rights extending up to 200 nautical miles without such restraints. There are at least 4 key points to be examined in relation to China's designation of no-sail zones. I will address each of these questions in turn. Question 1. Does China have the right to designate a no-sail zone within its EEZ, thereby prohibiting navigation by other states? Under the law of the Sea Convention, a coastal state has sovereign rights and certain jurisdiction in its EEZ. Designation of no-sail zone may derive from these rights and jurisdiction. Coastal states may also establish special areas limiting navigation in accordance with the international conventions and the rules. Other states, however, enjoy freedom of navigation in the EEZ of a coastal state. At the same time, they are obliged to exercise due regard for the rights and duties of the coastal state and to comply with its laws and regulations adopted in accordance with the law of the Sea Convention and other rules of international law. In short, the law of the Sea Convention does not provide detailed provisions on the no-sail zone, but rather seeks to maintain a delicate balance between the rights of the coastal state and those of other states. Notably, Article 19 of China's Maritime Traffic Safety Law provides that China may designate restricted navigation zones, including no-sail zones, for military purposes. Conclusion to question 1. A coastal state may designate a no-sail zone to enforce its sovereign rights. The establishment of a limited or temporary no-sail zone may be permissible. However, a general or excessive no-sail zone would constitute a violation of the freedom of navigation under the law of the Sea Convention. Therefore, the critical issue is whether China's designation of 5-day no-sail zone excessively restricts the freedom of navigation of other states. Question 2. Is there an obligation to notify the IMO or other states of such a designation? The law of the Sea Convention and other conventions contain no provisions specifically addressing the designation of no-sail zones, and thus no explicit obligation of notification. If a no-sail zone is legitimate under international law, other states are expected to respect it. However, if a coastal state fails to notify or publicize such a designation, it cannot reasonably protest against non-compliance by other states. In practice, notification to neighboring states and publication of such measures are necessary to ensure navigational safety. China didn't notify the IMO or South Korea. It only provided domestic level notification. The next question is would China's designation of a no-sail zone infringe upon the rights of South Korea? The EEZ of Korea and China overlap in the Yellow Sea, as I mentioned earlier. All three no-sail zones fall within 200 nautical miles of Korea's EEZ. In particular, one zone lies entirely on the Korean side of the provisional median line, while another straddles the line. The key question is that what specific rights of Korea, if any, are infringed? Fisheries, sovereign rights, or perhaps Article 74, Paragraph 3 of the Law of the Sea Convention, which obliges states not to jeopardize or hamper the reaching of the final delimitation agreement. Interestingly, the Korean government has not officially claimed that China's designation infringes Korea's rights. This may be because freedom of navigation is not exclusive to Korea, but a right enjoyed by all states. Nevertheless, Korea could argue that such designation infringes its sovereign rights in the EEZ and possibly violate Article 74, Paragraph 3. Since 2015, Korea and China have been negotiating their maritime boundary delimitation in the Yellow Sea. Conclusion to question 3, it is not clear whether China's no-sail zone directly infringes Korea's specific rights, but at least Korea didn't officially claim this. However, such measures may excessively restrict the freedom of navigation, or right of all states, including Korea. If China were to repeatedly designate such zones and escalate tensions, this could constitute a violation of Article 74, Paragraph 3 of the Law of the Sea Convention. The last question is, are other states entitled to designate a no-sail zone for military exercise within the EEZ of a coastal state? This relates to the broad issues of military activities of other states in the EEZ of a coastal state. State practice is divided in this issue. For example, the United States, Russia, and many other states support the permissibility of military activities in the EEZ of other states as a part of freedom of navigation. On the other hand, China, India, and other states adopt a more restrictive approach. If military activities are accepted as a part of the freedom of navigation, then the temporary no-sail zones may be designated for military exercise to ensure the exercise and navigational safety. However, such measures must not excessively restrict navigation. Currently, however, no clear standard exists. For the standards, in my opinion, the relevant factors such as duration, location, and prior notification can be considered to judge to meet the standards. Final conclusion. China may designate a no-sail zone within its EEZ for sovereign rights and military purposes. However, such measures must balance the rights of coastal state with the freedom of navigation of other states. And a 5-day no-sail zone, as designated by China, may excessively restrict the freedom of navigation. If repeated, such actions could violate Article 74, Paragraph 3 of the Law of the Sea Convention and hinder the process of maritime boundary delimitation with Korea. Thank you for your attention. Thank you.
Thank you, Dr. Park, for that insightful discussion of the importance of maritime boundaries and navigational freedoms. Next, we will hear from Ms. Dita Lilianza, who will address human trafficking and migrant smuggling issues.
Um, Thank you very much for the kind introduction. I don't know if I can just sit from here because I think I'm too short for this podium, so that I can, interact and then see others. I think that would be better. So thank you very much for the kind invitation, and it's been a pleasure to be back in India. This is my second time, and it's always a pleasure. And it's also an honor for me to share the panel with my esteemed panelists, and allow me today to really bring the issue back to where I'm from, which is Southeast Asia. But even though the focus of my presentation today is really on maritime security issues in Southeast Asia, thank you. And particularly, I will focus on two main issues today. But as you will see, that there is a lot of relevance to some of the countries in South Asia and even in other parts of the globe. So let me start by this horondogram, or a map of regional body. So this has not been updated. So please bear in mind that there may be a lot of updates required to complete this map, but this has been done since several years back. And as you can see here, I put ASEAN at the top, but there are also other regional bodies in Southeast Asia and beyond that deal with maritime security. And you can see there are a lot of them. And it's also all because most of the maritime security issues in Southeast Asia are dealt issue by issue. And as Southeast Asia's main regional body is the Association of Southeast Asian Nations, or ASEAN, so a lot of these processes are driven by ASEAN or within ASEAN or using ASEAN as the center. But as you may be aware, that ASEAN has 10 countries, including Indonesia, Malaysia, Philippines, Vietnam, and others. But then there are also these so-called ASEAN external cooperation. And that's when ASEAN works with countries beyond Southeast Asia on various different issues, including maritime security. For instance, ASEAN has several dialogue partners, including the United States as well as India, which is why at the down below you can see there is ASEAN-India Summit, because so that's basically the highest political body where ASEAN and India discuss various different issues of common concerns where they can cooperate and collaborate. And that can also include maritime security. But there are also other, which is a wider body that includes a lot more countries than just ASEAN and one other country. There's ASEAN plus 3 mechanisms, which includes South Korea, Japan, and China. But there are also the expanded ASEAN Maritime Forum, which also includes India as well as the United States. But there's also ASEAN Regional Forum and then the East Asia Summit. So all these are the relevant regional bodies in the context of maritime security. But also, you have to remember that the ASEAN as the central institution in the Southeast Asia is also key here. And because it works within pillars, within the socio-economic, political security, socio-cultural, political security, and economic. So there are also various bodies within ASEAN that deals with maritime security. For instance, the ASEAN Maritime Forum, as well as the ASEAN Ministry of Defense meeting, as well as the ASEAN Ministerial meeting on transnational crime. Those are just examples, but there are also other bodies within the other ASEAN bodies that deal maybe on very technical issues like maritime transport or fisheries, but there are also some overlaps like cross-cutting issues with maritime security. With that background, let me just summarize my observation about Southeast Asia regional governance. So in my observation of working on the issue of ASEAN and maritime security in the past 7 years is that sovereignty first approach is the very basic principle because of the history of majority of Southeast Asian states are colonized except Thailand. So there's always that fear and a lot of cautions about external interference, which is why you see a lot of process-oriented and then soft law dominance. This all goes back to the sovereignty first approach. So whatever cooperation Southeast Asian states are taking, especially in the context of security, because this is considered something sensitive. So they would always work on it through multiple meetings, and it always results in the non-binding instruments as opposed to a more binding and formal instruments. But as you can tell, because it's process-oriented and consensus-driven, it always leads to issues where they are the lowest, the lowest hanging fruits, because everyone has to agree on a topic, or everything that is coming out of ASEAN, everyone has to agree. So either everyone agrees or nothing's happening. And because it's process-oriented, so there are more than 1,000 meetings per year, so you can see, and those are dealing with various different issues. And unfortunately, coordination is still lacking. And because of that sovereignty-first approach and reluctance to binding instruments, you see hundreds, if not thousands, of soft law instruments produced by ASEAN. And which is why talking about maritime security in the context of Southeast Asia, even though it sounds small, it's actually a really big task because of the myriad issues and the many number of bodies that are involved. And well, ASEAN adopts a laundry list approach, so it identifies several maritime security threats, but allow me to just focus on the two issues that I've been working on, which is the irregular maritime migration and the modern slavery in captured fisheries. And even then, all these threats I put forward here are not meant to be exhaustive, so there are other threats as well, because ASEAN's approach is more broad and encompassing various issues. Even environmental threats are considered maritime security threats. So just an overview before I go deeper into the two issues is that this is just overview of ratification of key treaties in the context of the topics that I'm going to talk about today. Of course, most of the countries in Southeast Asia are parties to the Law of the Sea Convention, except Cambodia, because it has signed the convention but has not ratified. And unfortunately, many of the key source or destination or transit countries for refugees, none of them have ratified the Refugee Convention, but Cambodia and Philippines have. Even the Search and Rescue Convention, which is very much relevant when we're talking about irregular maritime migration, only Indonesia, Singapore, and Vietnam are parties. But fortunately, all of them are parties to the UN Transnational Organized Crime Convention, but only Indonesia is party to the STCWF, which is the standard for manning for fishing vessels. None have ratified the Cape Town Agreement, and only Thailand have ratified the Work and Fishing Convention, which is very much relevant when we're discussing labor issues on board fishing vessels. So let me start with the first issue, which is the irregular maritime migration. I'm sure some of you are not, most of you are aware of what photo this is. So like from this to this. And so, it started, so basically Southeast Asia has always been a theater where a lot of migration happens through sea, either driven by conflicts or economic opportunities. But the first one, it was the Vietnamese boat people, which from the 1970s. So it was considered one of the first irregular maritime migration by sea in Southeast Asia. And at that time, Vietnam was not an ASEAN member state. So it was the first time that, but even though Vietnam was not an ASEAN member state at that time, but ASEAN has been around, I think, for about 10 years then. So at that time, it was also approached regionally through non-binding instruments. And now it's even more challenging because now we see an influx of Rohingya migrants going through the Andaman Sea and the Bay of Bengal and going through the coastal states in Southeast Asia. And even UNHCR claims that 1 in every 69 individuals attempting maritime migration in Southeast Asia has died or went missing, and most of these are actually Rohingyas. And this is also very problematic because it's also mixed with economic migration. So there's a lot of issues happening. And I think the peak was in 2015, where about 5,000 migrants were left stranded by their smugglers. And it was estimated that 70 people died in this crisis, but other figures mentioned that there are actually 1,000 people died or went missing in this crisis. And it was a mix of Bangladeshi migrants seeking better opportunities overseas via people smuggling. And there were also Rohingyan people leaving Myanmar because of a prosecution and the unfortunate events happening in Myanmar. The most affected countries here are Indonesia, Thailand, and Malaysia, because they are the closest to Myanmar. So most of these migrants left stranded on the shores of the three countries. So initially, the three countries refused disembarkation. None of them were parties to the Refugee Convention. So, but most of these migrants were actually aiming to land in Australia. So most of the Southeast Asian countries in this case are transit countries. They're not exactly the destination countries. But because of the stricter border policies in Australia, they eventually became the de facto resettlement countries for all these asylum seekers and migrants. So what were the regional response? So please keep in mind, the whole characteristics of the Southeast Asia governance that I told you before. So there are, different kinds of responses. And it comes from different bodies within ASEAN and beyond ASEAN, ASEAN plus, or even extra ASEAN, meaning, outside of the ASEAN process. So because of the migration crisis in 2015, the ASEAN Ministerial Meeting on Transnational Crime actually came up with the Kuala Lumpur Declaration in 2015. And it was followed with the East Asia Summit, which includes ASEAN plus extra regional players like the US and India. That deals with the same issue. And then there's also the Bali process, which is a non-ASEAN institution. They are also trying to respond to the crisis. But I think the one thing that is shared among the three was that there is no reference to Rohingya or their rights or their status under international law. So there's very strong emphasis on law enforcement. So this crisis was framed mostly as a trafficking in persons and people smuggling without really talking or discussing the root of the problem, which was the possible genocide happening in Myanmar. And treaties cited concerned trafficking in persons, transnational organized crime, but there were no reference to the Refugee Convention or the Search and Rescue Convention or even other human rights treaties. So again, emphasis was really on law enforcement. It's also maybe because that was the lowest common denominator that the states could agree on, where the states could achieve consensus on, because this is considered a sensitive and a sensitive issue where it's very hard to reach consensus, even on just the mention of Rohingya or maybe the mention of refugee or maybe the mention of non-refoulement is considered sensitive. So there's a pros and cons of using the more like the low-hanging fruit approach or even the soft law oriented approach, but it comes with a cost. And since I only have 3 minutes, 3 minutes, I think I should be fine. So let me move on to the next issue, which is the modern slavery in captured fisheries. As you can see here, most of the major fisheries producers come from Asia Pacific, and most of them are actually found in Southeast Asia. And another interesting fact is that most of the people employed in fisheries are actually based in Asia. About 85% of the 33.6 million fishers working on board fishing vessels. And because of that, there were a lot of revelations around slavery on board fishing vessels, starting with the 2013 expose on Thailand fishing industry, and then there were also another investigation revealing potential slavery case in Indonesia's fishing industry, about 300 slaves rescued from Indonesia island. But even though these slaves were enslaved on board Indonesian vessels, but apparently it was still linked to Thai companies and Thai fishing vessels. And there was also another case involving Indonesian fisher being thrown overboard on board of the Chinese fishing vessels. There were several cases of a similar nature. And all this has resulted in various responses, but I think the one that was affected the most was the Thai fishing industry. Even the EU measure was mainly addressed against IUU fishing, but the EU even threatened trade ban over slavery in fisheries. So it was part of the discussion or dialogue between EU and Thailand when Thailand got yellow carded by the European Union. And as a result, the regional response has been, of course, soft law instruments, started during the Indonesia chairmanship, because I think more than 80% of the fishers working on board distant water fishing vessels that have become victims of forced labor are Indonesians. And so during Indonesia chairmanship in 2023, they managed to agree on the declaration on the placement and protection of migrant fishers to promote safer and fairer conditions for migrant fishers. And because ASEAN follows this dual-step approach where they have the more broader, the more general primary soft law instrument followed by a more technical soft law instrument like guidelines or action plan. So this is what they do. They come up with a very short declaration underlining their political commitment, and then they come up with a more technical with timeframes and funding. So I'm happy to take on questions, but hopefully this will provide a nice background for the Q&A. Thank you.
Thank you, Ms. Lilianza, for those important reflections. Finally, we welcome Professor Ademuni Odeki.
Can I start? Okay. Ladies and gentlemen, good morning. I'm glad to be here, and it's a pleasure being invited to this conference. It's my first time in India, although I was born just across on the western side of the Indian Ocean Rim. And even more interesting, I'm happy to present a topic which is very close to my heart. I will have in my presentation 2 maps and then a narrative based on those 2 maps. So I would appeal to you to look at the maps very carefully because I will not go back to those maps. Oops, sorry. Now, this is one of the maps, and this is the Indian Ocean Rim, which is what we are talking about. And we are talking about maritime security. And what we mean is basically that people who travel along this seawater, people who work there, people who have the living, and people who traverse it must have safety and security in the process of enjoying whatever it is they are doing. And what we are looking at is the harm and damage that may come upon those people when they are prosecuting their interests. This is the Indian Ocean Rim. And you can see from here that it's basically a very central water which contains the east-west sea route. Now that east-west sea route to me is one of the most important sea routes ever in the globe. It links the east part of the rim, which contains three major industrial countries: India, Japan, which is the third economy, and China, which is the second largest economy in the world. And it links that with Western Europe, which is a major industrial base, and the North America. And the shortest route there is the east-west, which comes from the Malacca Strait and goes up through the Gulf of the Red Sea, and then through the Suez Canal, then into Europe and North America. The other route, of course, goes from there across down to the Cape of Good Hope, then west. So it's very crucial. Now, the things that I need you to look out is that in terms of this rim, we've got hot points. Hot points are areas where there are skirmishes and violence. And those hot spots are represented by the star. And you can see that the hot points there are basically around the Middle East and around the Mozambique Channel, which is down here, and then, of course, further up in India and the East. So I want you to watch out those hot points, because those are the points which impose threat to the use of this water. Also contained in this map, of course, is the areas where there is piracy. And piracy is one of the major causes of maritime security. There is some kind of piracy in the Mozambique Channel. There is obviously piracy, or there was piracy, which is now dying down in Somalia. And then, of course, the Malacca Strait piracy, all happening in this rim. So I will move on to the next. Sorry, move backwards. Now, my presentation is focused on the northwestern Indian Ocean rim, okay? And this is a more highlighted map of the northwest Indian Ocean rim. And you'll find there that there are a number of hot spots, okay? And you can see there a number of hot spots. One of them is around the Somali coast because of the activities of Al-Shabaab, which is an insurgency. Then, of course, there's a lot going on in Syria. There's a lot going on in Israel and in Iran. When you tune your television, you'll know a lot of these things going on. Now, the other thing which I also need to emphasize that it's not only what is happening within the rim, and it's not only what's happening within the Northwest Indian Ocean rim. It is also other aspects which happen in the neighboring areas, like it cannot be divorced itself from the violence in Afghanistan, the crisis in Syria, of course, and of course in Iraq, and of course, currently one of the most important aspects is the violence caused by the Houthis in Yemen. So this area has got every aspect of maritime security that you can think of: the piracy, the violence, the migration, and so on and so on. Now, so my speech is going to be based on those two maps. Now, based on that, my narrative is as follows. One is that the Indian Ocean Rim is one of the most important areas on the globe. It's probably the most populated rim of any of the other ocean rims. It has got 3.5 million people out of 8 billion people that inhabit this earth. And that means also it's a very large market. Secondly, and this is most important, it's got the shortest and the cheapest strategic east-west route, which links the big manufacturing zones of east and west part of the globe. Thirdly, it contains the three most important choke points in terms of maritime transport. One is the Malacca Strait. The other one is the Gulf of Hormuz, or sometimes known as the Persian Gulf, and of course the Red Sea. Now, you can imagine that it would be very difficult to transport anything from Japan, China, across into this zone and then west without going through the Malacca Strait. Number four, this Northwest Indian Ocean Rim is also the source of 30 to 40% of the world's energy. It contains over 50% of the global container trade and over 66% of all the shippings involved in international trade. So you can imagine this is a very important area in terms of trade, and trade means everything to most of us. It also contains the most critical east-west underwater oil, gas, commercial, military pipelines, and communication cables underneath the sea. Now, if any of those come to any harm, it will almost dislocate everything else in the world. Unknown to most of us, a lot of communication goes through these cables, and a lot of oil and gas go through this. Number six, as I said previously, the Northwest Indian Ocean hottest spot on Earth. There's most of the violence and other aspects that have taken place are in this area. Maybe the next one is probably the South China Sea. Number seven, this area is well endowed with oil, gas, fisheries, seabed minerals, and other maritime resources. Apart from the 30 to 40% of the oil and gas which comes from the Gulf, there is also a large amount of oil which has been discovered in Somali Base, in Tanzania, and in Mozambique. So I think that very soon, about 50% of the world's oil and gas will come from this zone. Now, I've also mentioned that one of the problems is that it's not just the area is prone to these security issues, but they're also close to other hotspots like Afghanistan, Syria, Ukraine, and South China Sea, all which are, now, these affect what is happening in the Indian Ocean zone, rim, even if they're outside that zone. Now, a number of reasons, secondly, my next narrative is about what causes the maritime security issues in this part of the world. Now, a number of these reasons have been given for the maritime security problem, but I'll just list 7 of these and go through them very quickly. We can discuss the details at some point. The first one is the political instability and weak governments in this zone, which obviously leads to the failure to exercise sovereignty and control the area. Secondly is the geopolitical rivalry or tensions As you can imagine, because of what I've mentioned, because it's a very key area in many ways, it has attracted rivalry, not just between the regional states, but also foreign powers. And hence, there are a number of foreign military bases in this place. I will not go through those. Now, the other thing, of course, is, which is unfortunate, that the area is also prone from the ongoing Arab-Israeli conflict, which is very unfortunate. And that has a knock-on effect on security. The area has had 3 Gulf Wars. If any of you will follow it, there have been 3 Gulf Wars in the last 20 or 30 years. One of them was what was known as the Tanker War, when the fighting parties, were hitting each other's tanks. In addition to that, number 5, the area has also has hosted 2 of the most, probably the greatest modern piracies. That is the Malacca Strait piracy and the Somali piracy, which caused a lot of havoc to a lot of issues. Number 6 is the insurgencies in this area. There's an insurgency in Somalia. There's an insurgency in the Mozambique Channel. The Al-Shabaab in Somalia, the ISIS has operated not very far from there. Al-Qaeda has operated from there. The Houthis, of course, and Ansari, which is operating in the Mozambique Channel. Now, these have added on to the maritime security problems. Number 7, of course, is that the area has been, the zone has been subject to attacks on shipping. Now, if any of you follow issues on attacks on shipping, and my friend, the moderator will know. For instance, in 2000, there was an attack on the USS Cole by Al-Qaeda, causing a lot of damage. In 2002 was the attack on the MV Limburg. That was a merchant vessel. And in 2010, there was attack on the M Star. These are attacks on shipping. And these have happened in this. Lastly, obviously, is the current attack by the Houthis, who have so far sunk 4 vessels, detained 1, killed 8 crew members, and detained a lot of others. And of course, they have led to the closure of the Suez Canal. I'm only left with a short time, but now, in terms of the maritime security topics themselves, there are 7 of these, 8 of these which happened there. I'll just go through. Piracy I've mentioned, maritime terrorism, attack on shipping, trafficking, illicit traffic in arms and humans, and the use of weapons of maritime, mass destruction, and a lot of the others. Now, I think it's important that, I had this intention that we should not just gather here and talk about these narratives. We know these narratives are there. I think it's important that we try and find solution to these problems. Okay? Now, one of the solutions to these problems is to address the maritime issues in this zone. And that can be done through, 1, through regional cooperation, and 2, capacity building in various areas which affect maritime security in this area. And finally, there are other responses that would need to deal with the maritime security in this area. One of them is increased naval patrols. Secondly is information sharing and coordination among the member states and countries. Regional cooperation, obviously, and capacity building. And Mr. Moderator, if you may allow me to finish, I think that the key word here is the cooperation between the member states of this. There are so many bodies here. We don't need to create more bodies. There are enough agencies, enough organizations, the Indian Ocean Rim Association, there's the Indian Ocean Commission, and the Indian Ocean Maritime Rim has got a number of other sub-bodies that deal with issues in maritime security in the region. But I think, above all, somebody needs to take a lead, okay? And this is where, with due respect as a guest in this country, I think that there's one country that has the ability and the power, okay, to take the lead. And I think that country is India, okay? Not only because not only because the rim bears the name of India, but it's also the dominant country and the dominant power. And unless somebody takes the things, we can't. Now, I just want to mention the cooperation is very important. The Somali piracy was one of the worst incidents that you could ever have happening at sea. It was only solved by the United Nations and all other countries and regions and organizations coming together. At the peak, there were about, I think, 500 or 5,000 vessels. There has never been a collection of shipping, there has never been a collection of naval vessels. There has never been such a cooperation between member states of the United Nations and the world community as it happened in solving the Somali piracy. And I think that precedent can be used to solve the maritime disputes and the maritime security issues in this region. I thank you very much for your audience.
Thank you, Professor. We now have 25 minutes for questions and discussion. I invite the audience to raise their hands, and I'll do my best to direct questions to our panelists. Please keep your questions concise so we can hear from as many voices as possible. Does anyone want to start?
Good morning. My name is Captain Savan from the National Maritime Foundation, and my question goes to Dr. Park. This is when you spoke of the 5-day closure in the Yellow Sea. My question is, was this also promulgated as a navigational area warning? Because this falls under navigation warning area number 11, of which the coordinator is Japan and specifically the Japanese Coast Guard. So are you aware whether this was promulgated as a nav area warning? Because if so, then it is a done thing. Of course, 5-day closure is an unusually large amount of time to close an area. But to notify military exercises, I think that is the normal mode of notification, which is followed at least in Nav Area 8, where India is the coordinator. Also, I think that the authority to promulgate an exercise area in a different coastal states EEZ, I don't think that that authority rests with any country. Thank you.
Okay. Thank you for the questions. In the Yellow Sea, as you know, it is the semi-closed sea, right? And the Egypt of Korea and China overlaps in the Yellow Sea, and so in these days, the China and Korea's the military we exercise in the Yellow Sea, but in this case, when the China designate no-sail zone in the Yellow Sea, Chinese government didn't notify to South Korea, so we didn't know whether China establish the no-sail zone in the Yellow Sea or not. We noticed it from the Newsweek article, and the Korean government protest to China, and we expressed our concern about the designation. And so I think the Chinese government should have notified that to the Korean government or maybe Japanese government to secure the safety of navigation, but didn't. And I think the Korean government and Korea and Japan we maintain very close relationship to monitor and to patrol the relevant areas. And also we have some, we maintain some level of cooperation between Korea and Chinese Coast Guard. For example, we conduct some joint control to monitor and to catch some IUU fishing in the Yellow Sea. Yeah. Okay.
Makoto Seta from Waseda University, Japan. And my question also goes to Yonkyo. So thank you very much for your presentation. And so as far as I understand, so the no-sail zones were established at the provisional measure zone established by the China-South Korea fishing agreement. And so my first question is that so whether that agreement is regarded as a provisional arrangement provided in Article 74.3. Yeah, so 74.3 provides two obligations. One is to make an effort to conclude a provisional arrangement, and the other one is not jeopardize the hamper. And my second question is that if the no-sail zones were established in the provisional measure zones. So does this fact give the impact on the interpretation and application of the obligation not to jeopardize and hamper? So in other words, so what is the relationship between the first obligation in Article 74 paragraph 3 and the second obligation in the same paragraph?
Thank you for your question. And as you mentioned, the South Korea and China, we established the provision measure in the Yellow Sea, a huge provision measure based on the 2000 fishery agreement. So in that zone, the principle of flag state control applies in that zone. So each party cannot control the ships and the people of the other parties in the zone. But the provisional measure only applies to the fishery affairs, not others. So the provisional measure and the fishery agreement, as you mentioned, it is we can consider it as a provisional arrangement according to Article 74, Paragraph 3 of UN Convention on the Law of the Sea. And regarding the obligation, the first obligation is to make an effort to make a provisional arrangement, and the second obligation is not to jeopardize or hamper the reaching of final agreement, right? Final boundary agreement. In the context of the second obligation, the South Korean government we have very much concern about the recent Chinese activities in the Yellow Sea. And for example, the Chinese government has built two huge aquaculture facilities in the Yellow Sea and some kind of a control tower. So uh, well, we are not sure that the build of that huge aquaculture facility in the Yellow Sea in the provisional measure zone directly violates the fishery agreement or Article 74, paragraph 3 of UN Convention on the Law of the Sea. But we are concerned about the Chinese recent activities in the context of the Law of the Sea Convention. And also, we are worrying about the Chinese recent expansion, maritime expansion in the Yellow Sea as the gray zone tactics. So,
Thank you.
Good morning, everyone. I'm Saharsana Kapoor. I'm an LLM graduate from the University of Edinburgh. And my question is to Professor Odike. With the decline of Somalian privacy that can be largely attributed to the widespread deployment of PCASPs as well as the coordinated effort of the Combined Maritime Task Force based out of Bahrain, to what extent would you consider this model capable of being enhanced or adapted for the effective application in the piracy regions that you've identified through your presentation?
Hello. Thank you very much for the question. Let me just add before I answer the question. The problem with these issues is that there are so many issues is what we are talking about, and what we try to do is just to summarize, But otherwise, if we had the time to go through them, we would find that we need a lot of time. But in answer to your question, I have been writing quite a lot on piracy in this part of the world. And one of the problems that I have come across, or I'm wondering about, is that there has not been such a response to what is happening currently in the Indian Ocean Rim, especially the Northwest Indian Ocean Rim, as one would have expected. And it's difficult to understand, but my interpretation is that with the Somali piracy, it was affecting the artery of the global trade, okay, which is critical to everybody else. And the major trading nations stood to lose, okay? It was also threatening to block a source of 30 to 40% of global energy. And you know what that means. Without global energy, without this energy, the world will come to a halt. So there was a threat. Everybody felt there was a threat. Okay? And so the United Nations Security Council was mobilized, passed several resolutions. A number of major interests got involved. NATO got involved. They sent in lots of vessels. The EU got involved, not just as an EU bloc, but member states of the EU also got involved. Regional organization was set up, one of them being the Djibouti Accord, which you're aware of, and another task force, I think, was set up in Saudi Arabia to deal with these issues. I happen to be one of the happened to have been advising the United Nations at the time. And there were a lot of issues arising from the arrest of the pirates or suspects and where to try them. Most of the countries that provide the Navy were Western countries, okay? But they were reluctant to take these pirates back and try them in their own jurisdiction as provided for in Article, I think, 105 and 102. And these countries came together and decided on an alternative way of doing things, which was to persuade the regional countries within, which turned out to be Kenya and I think Somalia, to take these pirates and try them. And in order to do that, there had to be a link between the offense and the jurisdiction, although the convention provides for a universal jurisdiction. Okay, so eventually everything was solved. And there was so much involved. The UNDP got involved. They provided so much money. There was shortage of accommodation for the suspects. They built prisons. They did lots of other things. Now, so much, what I'm saying is, so much effort was spent, and there was such a unity among these, the international community. That has not been duplicated in this case. And one can only assume that they don't feel as threatened as was the case with the Somali piracy. I'm only guessing, because I don't understand. And I've been advocating for, say, why does the Security Council get involved? The Security Council, I think, has passed 2 or 3 resolutions on the Houthi attack, for instance. So it's mind-boggling. I don't have the to be very frank, I'll tell you, I don't understand. I'm as frustrated as anybody else. But I wish they would duplicate what happened in Somalia. We would have, a lot of the problem that we have would have been solved. Thank you.
Good morning, ladies and gentlemen. If I may just chip in to what the professor just alluded to, I was up front and center in the combat against Somali piracy when I was erstwhile in my civil service career, back in 2011 onwards. There was a threefold mechanism which came into play at that point in time. The phenomenon of Somali piracy of the Horn of Africa arose around 2008. So in response, the most cohesive intervention was done through a Security Council resolution dating to February 2009. And then the mechanism of the contact group on piracy of the coast of Somalia, that was the overarching mechanism, institutional framework, which was brought into play. CGPCS is the acronym. That was a 73-member nation body, supplemented by several international organizations such as Interpol, United Nations Office on Drugs and Crime, and what have you. But I think eventually everybody banded together, and I would completely concur with the professor that it was clearly undermining what we call as SLOC's sea lines of communication. It was extremely disruptive, and so everybody banded together under the banner of the CGPCS, which was the instrument, which was the binding element. But I think 3 factors contributed to the containment of piracy. One, and that was the major one, was deployment of 42 naval assets under the banner of EU NAVFO. Then you had the NATO, and then of course the combined maritime forces led by the US under the SHADE mechanism, Shared Awareness and Deconfliction, which was in Bahrain. So that was one critical element. Supplemented with that, where there were 6 independent deployers in the form of, in single navies. China was one such, India was one. India has had a naval frigate in that region since 20th of October 2008. It continues till date. So that was one critical element. The second which came into play was the adoption of the best management practices by the round table of the shipping companies, comprising 15 of the mega international bodies representing shipping interests. The third, to the point which the lady alluded to, was it was much to the chagrin of the International Maritime and privately contracted maritime security companies, PMSCs. So they came into play eventually. So all three cumulatively led to the containment of piracy by around mid-2012. Now, to the point that was flagged, why this has not been replicated, I suspect that the criticality of the nature and extent of Somali piracy is probably not perceived, or there's no felt need by international institutions. So if you were to look at what is playing out in the Red Sea in terms of Houthi attacks, it's not seen in the same prism. The globe doesn't see it in the same lens. It's partially disruptive because it's a very targeted, focused attack. They're picking out vessels of certain jurisdictions to clearly send out a message. So the disruption is not as severe as that. So I suspect, and this is something which I would even go further to say, that we've had piracy playing out in the West African waters, right? The Gulf of Guinea. Unfortunately, neither the UN nor anybody else deemed it appropriate to replicate that mechanism. So that's the long and short of it. Thank you.
Thank you very much. I think I'll just take on from where he left off, because I think the Gulf of Guinea became the hotspot of piracy, and nothing close to what happened in the Gulf of Aden happened there. Although the EU launched this coordinated maritime presences there, and you had the US, Korea, and other countries having routine patrols there. I think the underlying, in my opinion, the underlying factor was the fact that Somalia was a failed state. I think that's one critical aspect of it. And looking at the statistics the good professor showed, it shows how important that route or that region was. Because if you just suppose that in the Gulf of Guinea, we don't come anywhere close to the amount of trade and the volume of trade that goes on. Yet, the intensity and the amount of violence that it goes with piracy in the region kind of supersedes the Gulf of Aden. So the fact that Somalia was a failed state, I think, is one. And the fact that there was some sort of cooperation there, I think all those factors are being dealt with. I think we are seeing Somaliland, though there are breakaways, there's some form of government cropping up now. So the root causes are being dealt with. So once that is done, then you can see some progress. And of course, we all know, or most of us know, that a lot of conflict and other things happen because of fear and interest. The fear aspect and then the interest aspect. And this is not seen in most of the cases we find these days, either in the Red Sea now with the Houthis or in the Gulf of Guinea. So once those elements are not mixing up well, I doubt we see what happened in the Somali coast happening anywhere else. Thank you.
Thank you, Commander Dr. Hutton. This is Captain Gurpreet Khurana, professor at the Naval War College, Goa, India. If you permit me, I'll ask two quick questions. One is to Ms. Deeta from the NUS. This is regarding the South China Sea Code of Conduct. If you could let us know what is the progress on that, whether it will be legally binding, and more specifically in terms of China's insistence on having a text which disallows extra-regional powers like India in the South China Sea to conduct military exercises or even resource exploration in the South China Sea without the consent of all parties, which essentially means without China has a veto power. And how does it translate into the consonance with international law. My second question is to Professor Odeke. Sir, you said that India has got the potential to take the lead in maritime security in the region. I would like to know from the place that you come and the countries that you're talking about, essentially Middle East, what we call as West Asia, what is the impression there in terms of India's role in partnership with the US? I'm saying this in context of the fact that India, notwithstanding the fact that India falls within the jurisdiction of the Indo-PACOM, and yet India has joined the Combined Maritime Forces, which is led by the US in these waters, and the fact that my sense and my experience is that India's neighbors are not too comfortable with India's role as a net security provider, which is a tag which has been assigned to India essentially by the Americans, because it portrays some kind of a feeling that India has become a constable for the American policies and competition with the Chinese in the Indo-Pacific region. Your comments, please. Thank you.
Thank you very much for the question. Even though my PowerPoints have nothing to do with South China Sea, but I'm glad there's always a way for a South China Sea question. But I think I can answer it very briefly, as I'm not involved in the South China Sea Code of Conduct negotiation, but as I believe the negotiation is still ongoing, and if my sources tell me correctly, next week they're going to have another meeting in Singapore to basically discuss the code of conduct. But I'm not sure whether it's going to be binding or non-binding. I think it's going to be very difficult to have a binding code of conduct given Southeast Asia's preference to non-binding instruments, and I don't think it's going to be very easy to get a consensus on a binding code of conduct or even a code of conduct. To be honest, I'm a bit pessimistic about the COC. Yeah, I hope that answers your questions.
Thank you.
Yeah, thank you very much, moderator. Allow me to thank my friend in front here for supplementing on what I had said, and also just to mention what the gentleman at the back raised about the Gulf of Guinea. Before I answer the question at the back, I think what we understand is that countries take actions based on their national interest. Okay? Their national security, their national interest, source of oil and energy and all that. And I think it's because these countries perceive that the threat is not as it was before. The other thing is that the Houthi attack, for instance, is part of what's going on in the Middle East. And it's an amalgamation of so many issues: geopolitical issues, economic issues, military issues. There is the Arab-Israeli issue. There's so much that goes on there. Now, the Houthi attack, for instance, has blocked the Suez Canal. And it has meant that ships have now got to go all the way around the Cape of Good Hope, more or less doubling the journey, and costing more time, costing more fuel, leading to a lot of other things. But in the estimation of particularly the interested members, the people who are in position to do anything, in their estimation, that is not as bad as was the Somali thing. The Gulf of Guinea, a lot of people from West Africa are asking the same questions, are saying, why did you do so much for Somali piracy? Why are you not doing the same thing for the Gulf of Guinea? My answer to that is the perception. The Gulf of Guinea is not that pivotal in terms of global issues, security, energy sources, and so on. So that is the thing. Now, going on to the the answer from the speaker at the back. When I said that India should get involved, for goodness sake, I didn't mean that India should take up arms, go start patrolling the Indian Ocean. No. There are also geopolitical issues. India is having to deal with a lot of other issues, as you know, which is a fallout from the Ukraine war, the relation between India and the US and a number of things. So I think India has enough from that point of view to deal with. What I meant was that somebody need to take a position and coordinate, just lead the coordination. When I say give the lead, I don't mean you physically go and do it. If you can't, fine. I don't think it's possible for them to do. I think India played her part in the Somali piracy. And the role of India there was very important in what they provided. But I still think that we have so many organizations already in this area. We have the Commission, we have the WORA, and WORA has got a lot of other subdivisions. But as I said, as I mentioned in my speech, I think we need to go beyond just the narratives. Otherwise, we are going to meet in a conference like this, have a nice cup of coffee, meet friends, socialize, and then we'll be doing it over and over and over again. I think that we need to up the urgency, just treat it as a matter of urgency. Let somebody take the lead. I think the obvious person, the obvious party to take the lead would be India, but only in terms of coordination. Okay? I didn't mean that India should. I'm not saying that India is not doing enough. I think India has done enough, and I know that personally. I know that India is doing a lot in terms of military issues as well in the region. I think that's what I need to say. Thank you.
All right. I have been waiting for a while. Thank you so much. Thank you so much to all the panelists. It was a wonderful discussion. So in fact, I'm Sue from Center for International Law, NUS. I have a very general questions for all the panelists. So since the theme for this panel is on maritime security, and different panelists cover different issues as well, and international cooperations and collaborations was highlighted, which is very important. And maritime security was discussed at the Security Council this year. And UN Secretary General say without the maritime security, there will be no global security. So since this is such an important issue and it's part of the global security agenda, my question to panelists is that based on your experience working on this area, what is the critical issue or challenge that we face to move forward with the effective maritime security governance at the global level? Thank you so much.
It's a difficult one. But I think I go back to what I said. The critical issue here if what is happening in the region gets to the magnitude of the effect of the Somali piracy, then the world community will act. One, if you block the Malacca Strait and you cannot get trade flowing from Japan and China through, and if you block the source of 30 to 40% of the global oil needs, then particularly the major countries will act. But so long as that is not affected, I don't think there's going to be any action. To me, that is the critical point. We have not, in other words, to use the jargon which is used around the globe, we have not crossed the red line. The red line will be crossed if the threat gets either to the extent that Somali piracy did or very close to it. Then there will be action. But as far as it has not got there, it's the perception. Okay? Countries are weighing up issues. They're calculating, weighing up issues. There's a lot of demand on other issues. But so long as the critical point has not been reached, there will not be any action.
I am not an expert on the maritime security in terms of the military, so I'm studying the law of the sea. So I think that the critical issue in relation to the international law of the sea is one of the issues. The critical issue is that we have to build confidence on the maritime security issue in terms of the law of the sea. There are many issues. I think one of the important issues is to conceptualize or to make some concrete standards on the concept of military activities in the EEZ of a coastal state. And another point is that all states should respect the sovereignty and sovereign rights of coastal states. So I think this is the most important issue. Thank you.
Thank you for the very nice question. I think too, you're right to observe that we cover very wide issues ranging from different topics, but that just really means that maritime security cover such a wide range of issues. And with that said, I think one of the major challenge that, in my opinion, that I see today is, it has becoming more like a multi-domain security. So when we talk about maritime security, I don't think we can isolate maritime security from other domains. We've been talking about the land and ocean nexus in the context of security, but maybe I think now we have to start thinking beyond that. You mentioned yesterday about cyber, but there's also the space and maritime security nexus that I think worth more attention. Because of that, I think the maritime security issues will even be more challenging, because we are forced to also look into other disciplines and other areas, they are affecting one another.
Thank you so much. So I know we have more questions. Unfortunately, we're out of time, but we do have a break after this. So I'd encourage you to come up to the panelists and ask them your questions afterwards. And again, I'm sorry, but I wouldn't be a good naval officer if I didn't keep to time. So let me thank our three panelists once again. Each has highlighted a different and critical aspect of maritime security. On behalf of the Conference on Law, Oceans, and Policies, thank you all for your engagement, and please join me in a round of applause for our panelists.
Our sincere appreciation to Commander Chris Hutton for moderating today's session. Thank you for your valuable contribution to the success of this conference, sir. With that enriching discussion on mineral resource and maritime security, we now pause to extend our heartfelt gratitude. I would like to invite Professor Dr. S. Shantakumar, Provost, Gujarat Maritime University and Director of Gujarat National Law University, to felicitate our delegates. Commander Chris Hutton, our moderator. Our esteemed speakers, Dr. Yang Kil Park, Ms. Dita Lilianza, Dr. Admune Udeke, I would also like to welcome our rapporteur for this session, Insha Baba. Ladies and gentlemen, we will now take a short refreshment break. We humbly request you to join us promptly so that we may continue with the next session on schedule.
Please be seated, everyone. The session will begin shortly. Good morning, everyone. Welcome to session 6A on emerging technologies and artificial intelligence in the ocean. The ocean connects us all, and when technology joins in, the possibilities are endless, from safer navigation to smarter fisheries and better climate predictions. It's my pleasure to introduce our moderator, Dr. Manimuthu Gandhi. Our moderator is the former professor and dean at VIT School of Law, Chennai. With deep expertise in international law, he has taught and advised on subjects ranging from constitutional law to the law of sea. With deep expertise in the international law, he has taught and advised on subjects ranging from constitutional law to the law of sea, trade, and humanitarian law. He has served as counsel before the International Court of Justice and worked as a consultant for the UNDP and the UNCHR. We are delighted to have him guide this session. We are also joined in by a distinguished panel of speakers. Our first speaker is Captain Gurpreet S. Khurana, a serving missile warfare specialist of the Indian Navy with nearly 30 years of service. He has commanded 2 warships, authored over 50 papers, and several books on maritime strategy, and is credited with introducing the term Indo-Pacific into contemporary discourse. He is now an adjunct faculty at Nalanda University and visiting professor at the Naval War College, Goa. Today, he is presenting on the Muddying the Waters of International Law, the case of unmanned maritime systems. Our next speaker is Dr. Tafsir Martin Johansson, Associate Professor at the WMU Sasakawa Global Ocean Institute in Sweden. He holds a PhD in Maritime Affairs from WMU and an LLM in Maritime Law from the Lund University. His research spans Arctic governance, maritime decarbonization, AI in ocean systems, and biodiversity beyond national jurisdiction. He leads international projects on ocean technology and decarbonization and serves on the editorial board of Ocean Development and International Law. He'll be presenting on marine technology, saint or liability, taint, provoking the margins of public international law. Our third speaker is Advocate Rehana Denwade, a maritime legal consultant with Directorate General of Shipping under the Ministry of Ports, Shipping and Waterways. With experience at some of India's leading law firms, her practice combines international maritime law expertise with practical solution-focused advice. She'll be presenting on AI at sea at International Lens on balancing innovation and regulation in maritime governance. We're also honored to have Esri Ami Koloko, analyst at the Atlas Institute, who will be rapporteuring for our session. I now hand it over to Dr. Gandhi to lead the session.
And I'm sure this is going to be a very interesting session because, it deals with, the new technologies and how it is applied in marine domain. We know that the new technologies are very often used. Emerging technologies are to be used. That convergence of all the technologies that will help so many things there as far as the observance of what's happening in the sea, the first, then how to act in the sea with technology, whatever you target it like that. Because that is what, particularly that SDG, the Sustainable Development Goal 17 says that to achieve all these things, whatever the goal set to 2030, and we have to have all the emerging technologies. And the technologies are used in diverse fields. We have speakers well versed in their domain, but what is expected of here is that the marine science technology or the greater use of ocean observation, eradication of poverty, contributing food security, conserving marine environment resources, helping to understand and predict, respond to the natural events, and promoting sustainable development of oceans. So what are all the technologies we are looking for? Because some of the things, our panelists will deal with that, but there are about 7 areas where actually the marine technology that are applied. One is, it is to mitigate the climate change. The second is energy production technologies. And third is shipping technology. The fourth is, sustainable fisheries. And in the sustainable fisheries, targeting IUU fishing also comes in there. The technology can be used to map and just target. Then, technology for maritime safety and security. Because, in one or two the speakers, they'll just talk on that because you have a separate panel for maritime security, but the technology is very important in that context. Then finally, that international cooperation is the main element, and that converge all the technologies together in a targeted way that will promote the sustainable development. So finally, the targeting technology, when convergence happens here, and we have to change the present legal regime because that should suit the technology. Therefore, the cooperation is in fact needed not only to converge the technology and use it, then legal and regulatory aspects of the law, the present law that needs to be, adopted in such a way that will absorb the new convergence, new innovations, and the technical parameters. And the BB convention, the biodiversity beyond national jurisdiction, beyond national jurisdiction convention, you can find that how the convergence happens, right from the UN law of the sea and to the convention, the latest convention, 2023 convention, you can see that always the marine technology is always emphasized there, and the cooperation between states in developing and sharing the technology that has been greatly, asserted. So now the panel will present their views. I may ask first Captain Dr. Kruprit Khurana. And all of you know that it is only 15 minutes that is being allotted to all. So after that, you reserve the rest of the time for question and answer. Thank you, Dr. Khurana.
Thank you, Dr. Gandhi. Thank you so much for setting the tone and flowing from what you said. My presentation would essentially focus on hard maritime security issues, the legal framework for using these the technologies has become old, right? Whether it is wartime or peacetime. What I will do is I will restrict there are many kinds of technologies, right? So my presentation restricts itself to the unmanned maritime systems and also unmanned maritime systems which may be autonomous as well. And I will give you a naval practitioner's perspectives as to how the advent of these new technologies are creating ambiguities which actually dwells into a larger picture that as the technologies develop and are being used, are we chasing the tail? Because our laws are developing, but technology is also developing. So that is the broader question that we must keep in mind. So they are creating ambiguities in international law. And when we come to as I said, hard security issues relating to maritime security, they are creating problems for our rules of engagement. Now, I don't blame the audience, many of you who may not be aware of what are the nuances, what is the concept of rules of engagement. So I'll just take a minute to apprise you of what I mean by rules of engagement. So these are the guidelines drafted by the highest military authorities of the state for their commanders at sea, the commanders of navies and coast guards, to tell them that to what extent you can use force for your mission accomplishment in terms of maritime law enforcement. Of course, so these rules of engagement are not as important in wartime actually, because the wartime laws regulate your conduct to quite an extent. But so these rules of engagement become very critical when you're dealing with, say, non-state actors, or when you're dealing with gray zone actions of even states. And so the rules of engagement, a major component of that is international law. Of course, there are other components as well, such as the operational scenario and your national policy. So how this is happening? So as I said, I will look at this law at 3 levels. The first level is the unmanned maritime systems, whether it is aerial, surface or subsurface, they are unmanned. They are not autonomous, okay? So here the question comes when you have the rules of engagement, there are various types of rules of engagement. The most fundamental rule is the rule for self-defense. And that comes forth from the inherent right, as customary law, inherent right of individual and collective self-defense. So if you transpose that into the rules of engagement of a military force, it means the right of individual and unit self-defense. Now the question comes is, if you use an autonomous system like an aerial or a surface or a subsurface unmanned system, is it part of your unit? Is it an extension of your unit, whether it is a ship or whatever that you are operating? And so, can we use lethal force under the inherent right of individual and unit self-defense in response to a hostile act or intent by the adversary against that unmanned system, not against your ship? So this is a very fundamental issue. Now you will remember the case of MV Ruin, which was a pirate ship which was hijacked, which was a ship flagged somewhere but hijacked by pirates, Somali pirates, which the Indian naval ship INS Kolkata freed of Somalia only last year. And what INS Kolkata did when it was encountering that pirate ship, it launched its unmanned aerial vehicle for surveillance of that ship. It was called MV Ruin. And the pirates shot down that drone. And so INS Kolkata, as per international law, did have the right to fire, to use lethal force against the pirates, but it did not do. Of course, there can be many other reasons for that, for instance, the safety of hostages and all that, but then there have been instances other than that, when the threat from pirates or from grey zone operators was to the unmanned system, the military force of that state has not taken action. And one case is USNS Bowditch, the American ship which was operating in South China Sea, and this was not non-state actors. It was Chinese Coast Guard and Chinese Navy. So the USNS Bowditch had launched its autonomous, unmanned underwater system, a drone, underwater drone, and the Chinese recovered it. The Americans saw that their drone was being recovered by the Chinese, which means the question came, could they use lethal force against the Chinese? Because the drone had sovereign immunity. How can somebody take your drone, right? But they did not use lethal force. Again, of course, the reason could be that they did not want to escalate the situation with the Chinese, but then there has been a case of the American Triton UAV being used in the Persian Gulf in 2019 for surveillance, and the drone was shot down by the Iranian Revolutionary Guards. Now in this situation again, it was a very clear-cut case, a clear-cut ROE that lethal force could be used against the launch sites of the IRGC, the Iranian Revolutionary Guards. But the Americans said no. And if you would recall, some of you would recall, the US President Trump was the president in the first term, and you know what he said? He said it would have been unproportionate to shoot down the unmanned, for the Iranians to shoot down the American drone, and we launch an attack on the Iranian side would be unproportionate. And he said, quote unquote, we didn't have a man or woman in the drone. It would have made a big, big difference. You see, this is President Trump talking in his previous term. But the fact that I want to tell you is, so you are muddying the rules of engagement by getting in the element of unmanned drones. Now I will get the level one step, one notch higher to the autonomous systems. Now the autonomous systems, as I told you earlier, it's the same case applies for unmanned vehicles, unmanned or autonomous. All these have sovereign immunity. So if there is a unmanned drone of a foreign power which is in your maritime zone, and what does the law say? What does the UNCLOS say? It has sovereign immunity. So the only thing that you can do is to tell it to leave. Or if it is a submerged vessel, then you can tell it, you throw 5 scare charges, which is a signal to any submarine to surface, and you tell it to leave. But that you can't do that for an unmanned system, and especially if it is autonomous. How do you tell? Whom do you tell to leave? And you can't prosecute it under international law. Now, this creates a very major problem, because I'm sure many of you would not know, even I was not aware of a very important national position which the US Navy has taken. Professor James Kraska, in the morning, he talked to you about the Commander's Handbook on Maritime Operations of 2022. If you read it carefully, it has a position that the US Navy has taken a legal position that its submarines will transit through your territorial waters in dived mode, which is against the UNCLOS. Of course, the US Navy has not signed or ratified the UNCLOS, but it is also mentioned in the 1958 conventions, which constitute customary law. Now, if you see this, and the Chinese are going to emulate the Americans. You saw the Victory Day parade of the Chinese a few days back, and they showcased that underwater drone, which is autonomous, XL002. So they always follow the Americans. So in Indian waters, say in a heightened state of readiness, such as what you have, what the Americans have, the DEFCON 4 or DEFCON 3, if India, I mean, I can't divulge exactly what the Indian standing rules of engagement says in a heightened state, because it is classified, but at least this much I can tell you. In the heightened state, which is DEFCON 2 or DEFCON 3 to 4, the Indian naval forces will be forced to sink any submarine or a AUV within the territorial waters of India in the heightened state. And if it is submerged, how will you know it's a Chinese or an American UUV or AUV, isn't it? So these are some issues. And then I come to the last level of lethal autonomous warfare system. So that is something which has really made it very complex. Since 2016, there have been studies, there have been panels, including UN General Assembly resolutions. The general consensus is the lethal autonomous weapon system need to be banned. Okay, but it's not so easy. And why they need to be banned is something, at least to me, it is very clear. You know, humans have made much progress in terms of technological advances, AI and so on. But the question is, have humans been able to even understand and let alone replicate the human brain? I do not think so. And so can you trust the lethal autonomous system to take the right decision? So these are not only ethical issues. There are practical issues driven by common sense. Supposing if an autonomous lethal weapon system makes a mistake, so who will be held responsible under international law? Will it be the designer of the system, or it will be the military commander responsible for that? So, as I said, there's near global consensus on banning lethal autonomous weapon systems by 2026. But there are a lot of problems, and there are naysayers. And one of the naysayers is India itself, for whatever reasons it is. So the Americans are not happy with it, the Russians are not happy with it. So the Chinese are doing something very subtle and as very characteristic of them. So they want to do lawfare in this arena as well. They are seeking to develop the lethal autonomous system, but they want to project a public facade that they are against laws and they want to ban it. So what they are doing is they are defining the lethal autonomous weapon systems in a manner which is too narrow. For instance, they say if there is an impossibility of termination of an attack, or it means those systems which operate with indiscriminate effect. Now, if you label the laws only with these tags, then what are you doing? Those tags are banned in any case. Indiscriminate attacks are banned by international law in any case. So it's like, quite like saying, you know, that if you murder somebody with a particular weapon, specific weapon, then you should get capital punishment. I mean, this is funny, isn't it? Because murder is liable for capital punishment in any case, at least in India. So these are the issues which I thought they have got very strong implications, geopolitical implications, they have got implications for national security for India, as I mentioned, and so on. So the broader issue that we must keep in mind that what are we doing? Are we on track to adjust and evolve, develop our international laws in tandem with the advances of technology, or are we chasing the tail? Thank you.
Well, it's a very interesting observation about, you know, this gray zone of law, because the law has not developed, law has not been developed, but you are not activate how the law would develop. Either you have to take action or you defer all the time, you will not find any emergence of law. So the best thing perhaps would be, you have to set a standard that you have to use ordinary principles of international law of the sea, wherever it comes in, because you are the interpreter at the particular point of time. So this is very interesting analysis. Now I may hand over the mic to the next speaker.
Thank you so much. May I have the PowerPoint on the screen, please? Thank you. So, organizers, honorable moderator, fellow panelists, ladies and gentlemen, pollution from marine technology is a pressing issue, and this pressing issue often goes unnoticed. And unnoticed pollution from marine technology is what we identify as the silent factor. This may add to the existing concerns of marine litter if technology is abandoned or lost at sea because of technical failure, leaving components such as biofuel engines or solar-powered devices in the ocean. Now, examples are ripe. Far out in the Pacific Ocean, we have a graveyard, the so-called spacecraft cemetery at Point Nemo, where dozens of Russian and international space stations and satellites have been intentionally deorbited and sunk without the conduct of a proper environmental impact assessment. Ergo, this presentation seeks to highlight the scope, manner, and form of liability from marine technologies and how that plays along the margins of public international law. Ladies and gentlemen, technologies today are deployed either constant or periodic. We have constant technologies such as offshore wind farms, which leaves a lasting impression on the marine environment, and it does so because of its physical footprint on the seafloor, noise pollution during its construction, and or electromagnetic radiation during its operations. I think we are more familiar with these phenomenon, but what is more interesting is that there are also not so frequent technologies that we call periodic technologies, from the famous Argo floats to autonomous underwater vehicles to remotely operated vehicles, even technologies that can dive at a depth between 6,000 and 11,000 kilometers to conduct in situ sediment incubation, environmental profiling, and even continuous oxygen measurements. Now, these technologies, they also bear some type of unforeseen risks. Lithium batteries present hazards of chemical pollution, and they have the potential to interfere with vital biological processes such as feeding, migration, mating activities. And then we have new and emerging hybrid technologies for ocean science research. And as fantastic as these technologies are, the state responsibility for deployment and the negative externalities as well as collateral impacts from these technologies that use multiple sensors on board to capture multiple essential ocean variables, they have been underexplored and less studied, thus constituting a major knowledge gap. Now, I wanted to pick up on the word state responsibility from the previous slide. So when we talk about state responsibility, the tradition is to turn to the Umbrella Convention, United Nations Convention on the Law of the Sea. And you have their articles that talk about prescriptive jurisdiction where flag states need to implement laws and policies against marine pollution as a part of their prescriptive jurisdiction. And then you have in internal waters that coastal states may also prescribe laws and regulations as a precondition to foreign vessel entry. In the territorial sea, coastal states may enforce those laws and regulations as a part of their enforcement jurisdiction. Then comes Article 235, which calls for member states to implement a domestic legal system for prompt and adequate compensation. Unfortunately, the interplay between prescriptive and enforcement jurisdiction and emphasizing on Article 235, it all applies to vessels and not marine technology. This, of course, invokes a number of questions, but UNCLOS has not ignored technology. In Article 20, you will find underwater vehicles as a part of the innocent passage regime in internal waters. And this very incorporation opens up a can of worms. It invokes questions such as, is a marine technology a vessel? Is it a technology? Is it a device? Is it an equipment? And should it be treated as a vessel? Because if a marine technology is treated as a vessel, then the stricter regulations that apply to a vessel should apply to a marine technology. And that is where we need to understand the merits and demerits of this very question. And in order to do that, under the third pillar of the Future of the Oceans program funded by Nippon Foundation, we tried to find an answer as a part of our baseline study. There, we turned to the definitions found in a number of articles in a wide range of international conventions. And how we selected the conventions was based on two guiding keywords, pollution and liability. And those guided the selection. And then we moved forward with a forensic analysis. The forensic analysis was conducted to trace these many terms that you will find in the definitions of these many different conventions in the articles to their historical roots, to try and observe whether there was any flexibility in usage or whether there were any associations between vessels and the important features that you will find in a marine technology. For example, I've highlighted craft in red. For craft, we looked at the historical evolutions of the three branches, hidden craft, ambient craft, and you have manifest craft. When you turn to hidden craft, it is used synonymously with what we call tacit knowledge. And marine technology, even if it's an equipment, it draws on tacit knowledge, unarticulated and unconscious knowledge that provides the basis for further actions and conscious mental states, and that is tacit knowledge. So the connection is there, but unfortunately, this forensic analysis did not yield positive results because at the end of the day, when we produced a publication, a draft publication, we felt that the connection was too forced. It was not convincing, but we needed to move forward with more convincing grounds. And to substantiate those results, we turned to judicial decisions where courts adjudicated on matters related to marine technology. And here is a case from 2002, a Canadian case, where the court unleashed the full potential of Section 2 of the Federal Courts Act. In the first instance, the court drew parallels between a remotely operated vehicle and a vessel. Considering ROV as a vessel, the court then proceeded to adjudicating the matter. But the court, in this case, also noted that the decisions were specific to the facts of the case, and the court did not make any general pronouncements that from 2002 onwards, all ROVs in Canadian waters will be treated as an ROV. The court also rejected the notion that there is a general overarching principle that will help determine whether a marine technology like an ROV can be treated as a vessel, thus emphasizing on a case-by-case basis. I wanted to pick up on the Bowditch case that Captain Kurana mentioned earlier. So, and before that, I wanted to mention that high seas governance depends on the nationality of vessels and vehicles, and currently we don't have any uniform registration regime, and the absence of standardized rules has kind of created inconsistencies. Case in point, Bowditch, when they deployed the autonomous underwater vehicle to survey the underwater channels in the South China Sea, yes, Bowditch claimed sovereign immunity, but the Chinese authorities that seized the AUV, they contested its status as a government ship. I'm not going to go into the politics of it all, but I'll move forward with saying that these issues will have an important bearing on liability. How can we determine liability in national jurisdiction? And liability in ABNJ is really not a new topic. This was raised by the Group of 77, otherwise known as G77, comprising of 134 developing countries, and they advocated for a fairer international order. During the BBNJ agreement, they noted that there were concerns because of environmental damage led by powerful corporations that deployed technologies in the marine regions. And their proposals included stricter accountability, responsibility, and especially a compensation mechanism for environmental damage to biodiversity. Unfortunately, this initiative was nipped in the bud due to political reasons, and therefore the complexities remain. So the problem is that in areas beyond national jurisdiction, things are a little bit tricky for the moment, because there you don't have rules like the rules of that classification societies have developed. They're recognized organizations acknowledged by International Maritime Organization, and they have indeed developed procedural laws for aerial drones, magnetic crawlers, and ROV, which is in fact a marine technology. It goes underwater. But these procedural rules will not apply in ABNJ because these procedural rules are for vessel classification and statutory purpose, right? They were designed for that. In areas within, states have the power, different levels of power, whether it's zones of sovereignty, whether it's zones of sovereign rights. States have the power to legislate and enforce whatever needs to be done. But in ABNJ, that power does not exist to a great extent. So will there be any implications on civil liability rules in the ABNJ? We again turn to our good old Article 235 that mentions that states will be responsible for breach of international obligations. And once the BBNJ agreement comes into force, this will be treated as a breach, and thereby invoking some of the important mechanisms as a solution. You have mandatory insurance, you have compensation funds and trust funds where payments are directly or indirectly tied to operator liability. There's a small window of opportunity to explore some of these important queries in detail, and of course the BBNJ, hopefully it will enter into force after 120 days after the date of deposit of the 60th instrument. But until then, we could look at some of the important liability aspects. So we have, for example, fault-based liability, which is a good solution where the manufacturer, owner, or operator could be held responsible. And here, the concepts such as due diligence and reasonable care will be important to determine fault. So the central theme of fault-based liability is based on causal nexus, where we ask the question, was the cause of harm close or proximate or remote to the actions of the manufacturer or owner or operator? And in this slide, you see that I've drawn three lines of three different lengths, and the line that connects the action of the operator to the fault is actually the longest, and thereby the operator will be held responsible simply because of the notion of foreseeability, because for autonomous operations, the outcomes are rather unpredictable. Then we have in the second instance, and I've drawn this from the discipline of management, you have an organization, manager, principal, operator, all top managements that will be held accountable for the tasks or for the accountability incurred during the execution of the tasks by an employee, a subordinate, an agent, or a technology. So the main theme here is that while you can delegate tasks to people, to subordinates, you will still retain the responsibility. So in this case, the operator will be held responsible for the liabilities incurred by technology. Then finally, we have strict liability, another famous notion where only the producer or manufacturer will be held responsible for a defective product. Case in point, the EU Product Liability Directive. Although the directive does not define technology as a product, it does mention electricity through which the connections can be made, because these technologies will use battery-powered sources. And in that case, if a marine technology incurs liability, then the operator will be held responsible. You do not need to find the approximate or remote causes or exercise due diligence. So, ladies and gentlemen, allow me to draw some concluding remarks. So anything that goes into the ocean, we have 102,899 ships of 100 gross tons and above that is responsible for greenhouse gas. We have 5.25 trillion plastic particles of different sizes in the ocean. We have deep sea sediments that contain plastic concentrations. Atlantic, Pacific, here in the Indian Ocean, where 800,000 plastic particles per cubic meter is found in deep sea sediment, which means that deep seabed is a big reservoir of these plastic pollution, right? So anything that goes into the ocean is a big concern. And here, technology is no different from plastic. The only difference is that a technology will function or malfunction. And if it malfunctions, there needs to be a framework that governs a technology. And of course, there are many new and hybrid models of technologies, and no two technologies are the same. The liabilities will be different, and that is why we will need to identify the profound differences that differentiate different classes of information. And at the end of the day, we need to make sure that we don't stifle innovation. Operators will need technology. We need to understand and explore the ocean. We don't know so much about the ocean. We need to make sure we understand biodiversity. We need to move forward with effective conservation and sustainable management of the ocean. A few publications that have been extremely useful for the development of this slide. I have books on autonomous vessels and smart ports, should anybody be interested. And then there's the Cambridge University Press publication led by Professor James Kraska and Professor Yunkil Park. And of course, the very recent publication led by one of my colleagues, Professor Aspasia Pastra. This was published in Frontiers in Marine Science. And with this, allow me to take a bow. Thank you very much.
Thank you very much. In a short time, we have wealth of knowledge about this thing, but finally we see only the gray area where solutions are, cry for solution, that kind of an area that we are looking. And traditional liability regime or the international public, I don't think, that will work very clearly here. There needs to be a combination of all these things, maybe while reflecting this, the answering the questions, if it is raised, you'll be able to just explain. Thank you. Please, next.
Very warm good afternoon, one and all. What are the, I also took key takeaways in how, so can we remote, yeah, remote.
Oh, sorry. Thank you. Oh, you have a PowerPoint.
Sorry. So I'll be only focusing on the governance aspect. Being representative as a legal consultant and advisor at DJ Shipping, where I come across a lot of different aspects respect to not only technology, but India is one of the seafaring providing nation which is highest in global. What are the other concerns that when we are going rapid ahead with the technology needs to be tackled with in terms of governance? I think in the beginning of the session, Dr. Gandhi mentioned that there are 7 areas of the technology governance. These are my drawn conclusion and the pillars of digital maritime governance, which is infrastructure, artificial equivalence, which also talks about how legal regime of the documentation should be well enough so that it doesn't challenge in the court of law. It should hold the possibility that there isn't a lot of concurrence around it. There is also a maritime I'm just unable to see. Thank you. Then there is also maritime cybersecurity and sovereign data governance, which is also an essential aspect which needs to be taken care by the governance. With how this data would be governed, and there is no such cyber code, if at all, developed with the developing nations. Digital compliance and surveillance with the transport and with the governance aspect, which also talks about the transparency. Then the future reality of the workforce and the collaborativeness with all other developing nations. The future-ready workforce is also, I think, one of the challenges that we are going to face ahead. What AI autonomy offers, I think we all know how it helps in navigation, safety oversight, mass potential, regulatory innovations, and digital transformation and policy changes, that how we have recently discovered there are so many lacunas which will not be covered in the existing international framework, and coming up with the mass, which also get into the different dilemma where operators' roles and the governance challenges are going to be there. AI potential for developing countries, if we talk about, then there are a number of that I have. It is not an exhaustive list. First, I would say the leapfrogging legacy system, which enables, which means that most of the developing nation doesn't have very apologies, doesn't have the current up-to-date digital data systems, so most of them are dependent still on the physical data files. If with the AI autonomy, I think it would be very helpful and they would not lag behind. There is also concerns of the safety in coastal inland waters, which we faced recent incidents of MSC ELSA 3 and 1 high had happened. I think with the AI interception, there would be a better challenge, better effectiveness to respond to such emergencies, along with, if at all we come across met or see any epidemic or pandemic hits, I think AI autonomous vessels without the crew would be very helpful in these kinds of a situation where we can assist with the life-saving appliances. Also, then there is a bridging gap of the governance deficiency. There are so many deficiencies in the due to the lack of technology, since the developing nation doesn't have mostly all of them. So the governance would be in a better way if we come across with the AI tool used in the governance. Then also there is an inclusive connectivity. I think in the yesterday's panel, a lot of people have discussed on the SIDs in developing nations, where we talk about there is a need of developing nations to come together and come on the point where we can grow together. I think AI autonomy helps in a way that we will not be lagged behind. The governance and legal dilemma, I think I would go just brush through it because all other my co-panelists have already talked about how STCW, if we talk about, it doesn't cover, it only talks liability of the crew and not the softwares. If he comes with a collar rigid talks about only human intelligence and not the AI autonomy, how it will judge the situation. Against the SOLAS liability, I think we have discussed this. Sir have also thrown light upon it. SOLAS is how if the certain situation come up, who will be responsible, whether the operators, whether the software owners, company, or the governing nation. Then there is a safety concerns with mass challenges, that there are a lot of definitions which are not cleared. India have also submitted paper on this during the scoping exercises about these undefined definition and dilemma and the SOLAS. Also, there is a legal and regulatory aspect which needs to be look upon, because the laws are, most of the developing nations are so outdated that they are not ready to tackle with these upcoming technologies and the liabilities aspect that would be covered. Emerging risk in digital maritime governance, these are some of them that I've outlined: cyber threats. Then there is environmental impact, which we have not covered. Now BBNJ is coming in. I think with that, whether all other liabilities are covered under BBNJ is also a question. Then there is a security risk. Last sessions, I have heard a lot of co-panelists talking about there are certain incidents of cyber security attacks in Japan and Australia. How we are going to tackle that, that would be a question. Then there is a data governance deficiency. Not all the developing nations are equipped with the current digital systems. This assessing AI governance and challenges in developing maritime nation comes down to these aspects, which are digital divide in infrastructure cost, which is very high. We cannot consider that the data centers, the infrastructure that it requires, the officers in the developing nations are not very AI literate, and they don't have a good hold over the digital dilemmas that would come across. For that, we need a lot of co-curriculum courses or maybe awareness about that. Then there is a workforce skill gaps which are going to be there. Regulatory and legal lags due to the outdated laws. Interpretation and the standard barriers would be there. Cyber vulnerabilities, of course, because developing nations, of course, come around with this aspect, which will they face the challenges. Now the core argument and how India's balanced and evolving approach would looking forward to it. I think India gives a refreshing outlook, how we are looking when we have to keep pace with the coming technologies. I think a lot of arguments I've heard during 2-3 days of the entire session, but I would say that the change is inevitable. Even the developing nation has to come up in a race and come with a way where there is a balancing approach, where I think India's perspective would be very helpful. India's strategic regulatory inputs on mass, first we clarify the mass operation definitions where India has submitted and contributed. Also, we have recognized the remote operators as a seafarer. Seafarer should be the center of it, as we were suggested that there are 3 degrees of the handling of AI autonomy on the unmanned vessel, where the seafarers, without the seafarers, I think vessels are not coming in picture in some few years, maybe in our lifetime. Support for hybrid modernization and integrating conventions with the mass code. I'm so sorry, I'm having a little difficulty with reading the words, but I'm picking up. I hope it's visible too, yeah. Realizing the quality and human oversight that also India highlighted during the mass scoping exercises. Support with the implementing degree-based regulatory strategy, as it would be very helpful for the developing nations, which has a vast amount of workforce. And if AI autonomy coming in near future, how they are going to be employed. So we have supported the degree level based regulation strategies as well. Looking ahead, Maritime India Vision 2030, and see which talks about digital infrastructure, mass code, which have been in talk now, but incorporate that in our national legislation. And on these blueprint, now you will see in my presentation, we have how incorporated these practices in the governance. The digital governance in the new Merchant Shipping Act 2025, I think that we need to talk about. After a long decade of Merchant Shipping Act 1958, now we have seen, which have recently passed in the Parliament last month, Merchant Shipping Act of 2025, which would be in force after the 6 months in regulatory discussions with the stakeholders in rulemaking. What new Merchant Shipping Act offers for the developing nation where we could incorporate the aspects like AI, mass as well. It enables electronic data records for the ship and operational under Section 3115, which says that lays down the foundation for the mass, which says that we have digital compliances and data authentication can be done through it. Then there's an ensuring of transparency of shipping charges. All the shipping charges that are being taken by service provider, be it in the entire shipping industry, would be covered. And that would be transparent with the data. Ensuring issue certificates, which would be, again, a laying down foundation. There is a tech-neutral inspection. The ship survey inspection is now going to be digital with robust cyber data back. Again, there is a flexibility with the vessel definition. So there are definitions that have been incorporated in the Merchant Shipping Act, where vessel is everything that is watercraft, can come under the vessel definition, which would be, again, further, it gives the scope for the mass autonomy, any kind of a vessel to be incorporated under the watercraft. Again, there is support of the safety and detailed compliances that have been incorporated. There is a grant of power with the central government to incorporate any such rules or remove the difficulties in the governance. So in case there is an implementation of AI and the mass in near future, it gives the power to the government to govern it very nicely. Then there is also a cyber code guidelines which is being developed under the aegis of Ministry of Port Shipping at the Directorate General of Shipping. Digitalization in maritime training, I'll run through. Okay, digitalization in maritime training, we are focusing on more of these key aspects which are there on the screen. We are coming with the modular courses, team stimulation-based certification. India is only one of the developing nations which allows the hybrid mode of certification for the seafarers. These are the key driving maritime digitalization India key initiative, which includes shipbuilding financial assistance policy, which governs under IRS, is also come up with the Indian Registrar of Shipping coming up with the mass guidelines which develop for the autonomous ships. There is a Sagar Mala program, which is digital transformation, which governs a lot of digital initiatives that would be done, and modernization of port. Autonomous ship design, which is already have covered. E-governance platform, DG Shipping have come up with the robust e-governance platform, which 60 plus modules which covered if there is a possibility of any future AI related technology invented. Research and development R&D, we are investing a lot in, where we have a lot of cooperations with IIMTs. We are developing on wave strategies and studies in weather forecast, which would be very essential and helpful, and how in lines with Norway and US is doing right now. India's distinctive regulatory framework also incorporates these following national logistic policy, anti-WPC, which is worked under aegis of Ministry of Port Shipping, which only focuses on data-driven AI technology related. Then there is a mission monsoon, which is again under the aegis of Ministry of Earths and Sciences. Lastly, the regional leadership that we have done is multilateral cooperation. We have IMO Shadow Committees portal coming in, where we are coming up with the better comeback at the approaching at the international levels. These are the maritime cooperation, I think, needs developing country to incorporate, to collaborate with a lot of countries, which would be the key for the developing nation to go ahead in the future. Chartering the fair course, to come to my conclusion, I would say the main challenge that remains with the developing nation is that when there is a technology, then there would be an aspect of a governance and the mass. first they need to build the capacity to have that technology, and then there would be a question of the governance. That would take a lot of time, and these challenges have never been considered by developing nations. Also, there is dependency of social challenges because the workforce is a lot in the developing nations, and the AI is somewhere going ahead with unmanned vessel, which would be a challenge to incorporate such technologies in the India. Also, strategic commitments, I would say how India have given the fresh outlook that you need to build your national laws in a way that it incorporates the future incorporation of AI technologies. It has a Swavit and ferry trials that have been done with assistance of the Cochin shipyard, which has also been governed under Defense Ministry in the privacy aspects and the governance of it, which is a pilot project. Along with that, there is lastly, I think I say that there needs to be an inclusive partnership so that all the developing nations would come together and have their own set of shares in towards the digitalization. My last words, I would say, the developing nations, when we see they had to be coming together and have such robust framework where it is inclusive and not exclusive. Thank you.
Thank you very much. It's a very detailed thing because, the panel presented it in 3 directions. She was about, she explained everything about merchant shipping in the maritime domain, when technology, how much technology you can use. He said, it is in the maritime domain, it is the Navy, and the strategic response, how it should be. The other gentleman, he rightly said that, this maritime technology, if we are using it, the technology in maritime area, especially in biodiversity and other areas, environment, biodiversity, climate change, and all these things, how it works. So all the 3 were able to just present a view that from 3 angles. Now the floor is open. Any questions? Yeah.
Thank you very much to all the presenters, very interesting. I have a question for Professor Johansson. So you talk about liability, but I was wondering about robotic systems and artificial intelligence. Do you think it is possible to have fictitious personalities for this type of technology to render, for example, civil rights? And if so, which liability could apply? And a second question coming from this first one is, if these rights will be recognized, would that inhibit the development of the legal framework, or where should it be developed? Thank you.
May I have the first question again? I'm sorry. The first question, please. Again, please.
It concerns robotic systems and artificial intelligence. Do you think it is possible to have fictitious personality as to render them, having them some type of civil rights? And if that is possible, which type of liability should they apply?
Yeah, so I'm just going to pick up what I said in the very last slide. So technology is a product. Unfortunately, there is no ontological grounds for calling a technology a human being. You can give it rights. Case in point, go back to company law, mercantile law. Companies have been given fictitious personalities, right? So they have rights. They have accrued rights, which means they will have responsibility to that end. So I think technologies can be given civil rights, but in a very limited portion. That being said, there are scholars that are opposed to this because should technology incur liability, how are you going to impose criminal sanctions on technology? Because for criminal lawyers that already know, you need to understand mens rea, you need to understand guilty mind, you need to understand actus reus. Yeah, go back to the classical terminologies. How are you going to apply those to a technology, right? So it has to be done in a under a very careful consideration. But yes, I think civil liability rules should apply to technology. You never know where AI is. AI is the brain the software. You never know where AI is going to take these robotics, right? So it's always good to, I mean, my parents always told me prevention is better than cure. Second question, please. Second question, please. Yes, sorry.
Yes, so if this happens, if in this limited way that you mentioned, that some civil liability and rights are recognized in this AI technology, where should the legal development be?
No, of course. So yes, so you can do it. Let's look at the customary international law. Let's look at the umbrella regulation, right? So if you want to do it top down, that is fine. But at the European Union level, from where I come from, it's pretty much trying to govern artificial intelligence. Governing artificial intelligence is not going to help govern Part C, Annex 2 of the BBNJ agreement, the tangible robotics, right? So AI will not help govern the entire landscape of robotic systems, the ones that are tangible, the ones that are mainly or could be responsible for a certain liability. But then you have self-regulation, which exists in chemical and the nuclear industry. It has also, interestingly enough, you will find that in disciplines such as law, accounting, and medicine. So self-regulation is a worldwide phenomenon. And you have a lot of organizations that play an important role in implementing laws and regulations for oversight. But that being said, self-regulation has been criticized by many people on the grounds that you can never truly achieve self-market discipline due to internal conflict of interest. Then you have principle of participation, non-representation, voluntariness, you have legal uncertainty. These things shroud self-regulation in ambiguity, right? So these need to be taken care of. So my standpoint is that neither nor. You need to go for a more hybrid approach. Look at the horizontal aspects where you can take into account the economical aspects, the geographical aspects of deployment, then take the vertical angle, the different levels of government, how they can come together for robotics and AI implementation, and finally the terrestrial, because I'm talking about maritime and ocean. Look at the terrestrial developments, what has been done, bring in the good lessons learned and best practices. I'm sorry if I failed to answer the question, but yeah, thank you.
Your question is to whom? Gentleman, general panel. Yes.
If I may, to the whole panel, that was a I'm Charlie from the Ministry of Foreign Affairs of Thailand. A question to the whole panel. That's a fascinating talk, and as you mentioned, the current status of law of the sea does not quite encompass, new technology as yet. In the field of international humanitarian law, on which I also work, states are negotiating the questions of technology, AI, and how that fits into the current framework of international humanitarian law. States are recognizing that the old framework does not suit or does not fit the question of cybersecurity and that sort of thing. The question is this. The question is, do you think that the current status of the technology as it stands requires some sort of measure of the international community to negotiate or at least agree on how the current law that was created 3 or 4 decades ago fits the current status of play? Thank you.
Yeah. You want to say anything? No other question?
Yes, your observation, I think I tend to agree with it. It's you're talking about unclauses essentially, but I would take it. I would even broaden that structure to the wartime issues. For instance, the laws of wartime, the laws of armed conflict are really very underdeveloped because you have the Hague Conventions in the early 19th century and so on. And of course, now you have the UNCLOS. But because of the current geopolitics, to my mind, it is very difficult for us to sit down together and have some kind of a consensus to revise, if that is what you meant, the UNCLOS and of course the laws of the armed conflict. We do not know what's going to happen, but we all know the kind of turgidity in the global geopolitics today, which is much, much more than in the 1970s when the UNCLOS, the third conference on law of the sea was at. So I guess it's not a very clear answer, but I guess we will have to live with it. We are making small strides in terms of the BBNJ agreement, which is now pending ratification by countries. So these are small steps that we can take in terms of navigating the complexities, legal complexities we have. But if there are some quarters which say that, okay, we can revise the UNCLOS, I think it is wishful thinking. Thank you.
I'm dubious as to whether I am eligible to respond to that question because you come from a very humanitarian standpoint, but my response would be brief and short. Even a fortuitous constellation of balance of power, an iteration of interaction, or a long shadow over the future cannot guarantee that actors, both state actors and non-state actors, will be able to come together for constructive dialogue and discussions to address issues in relation to robotics and artificial intelligence, but nevertheless, we will continue to strive. Humans like to be in control. Again, sir, it's not the technology that is the problem, it's the people that is actually in operation or operating that certain thing. They need to think how they want to operate a certain technology. You can do it both ways. You can either go north or you can go south, and not literally, but thank you. Do you want to respond?
My perspective would be, I would say AI may be the pilot, but the governance hold the compass. So there would always be a humanitarian ground may be considered in future, but not in our lifetime. I'm seeing that the old conventions and the laws would be there to change completely, and then there would be a control of total unmanned vessels, since the compass would always in the governance hand. Thank you.
I think since you are coming from the humanitarian law background, you know that there happen to be a lot of working groups working on that. How, the modern techniques that can be used and how that would affect existing regime of humanitarian law. And to my mind, 95% of the countries, they don't want those principles to be changed. All fundamental principles of humanitarian law. So despite you have this technology today or some other technology tomorrow, what happens is they will try to interpret the law in such a way that to meet and address the situation, they don't want to change it. Finally, what happens? Johansson was very right that it is, after all, your mind, where you are using it, for what purpose you are using it. So all matters are very clearly given there. So the point of view you can take very easily that it is, after all, the command and control that is the only principle accepted in terms of humanitarian law also. It's not matter which AI is used or some other, the mechanism that is used. It is most advanced or less advanced. What's the result? So, in law you can find that the same thing, you can find two important things. You can regulate either the contact or the result. Beyond that, you can't go anywhere else. You can come and you can have 1,000 seminars on that. Either you regulate contact or result. So regulating contact is a problem because he says that again, it is a mind. If it is a mind, the AIA says that it is a mind. It doesn't have a personality. When robo is there, it is a complete full-blown personality. Only national legislation you can give, the personality, like one of the South Korean laws, they conferred the personality on robo. But most of the countries would not like to do that. But another complication is there because the AI system is evolving. It does not evolve. When something is only in a very early stage, nascent stage, you will not be able to, come with a regulation. We will come only with a soft law, and the soft law either at the national level or the international level, and later on that will converge into, after 10, 20 years, a standard that can be accepted by everyone. I think, I answered your question. Mr. Shetty.
Good afternoon, ladies and gentlemen. Am I audible?
Yeah, it's audible
okay,
to us.
thank you. I was fairly fascinated, also intrigued by what was being unfolded in the deliberations. But kudos in the first instance to all of you. The sheer complexity and the extraordinary diversity of the emerging technology paradigm, it's simply mind-boggling. Just to take a cue from your response to this lady, that if you do not attribute the functionality of a legal person, there's a human person and there's a legal person to these emerging technologies. I'm just visualizing a worst-case scenario. If technologies go rogue, all right, and this is not in the realms of fantasy, okay, we are living in a real world, both from state actors as well as non-state actors, then what happens? Now, for instance, I'll just get the nuance of, in terms of what was dwelt at length about the potential for cybercrimes. As you're aware, there is now a United Nations Convention against cybercrimes, which is at a very, very infantile stage, which has been now opened up for signatures from 24th of October 2025, and it'll be available until 31st of December 2026. Can that be applied for technologies such as this, which could go potentially rogue? I'm even doing louder thinking. Can you apply potentially sanctions against these technologies? What happens? I mean, just sort of wanted to flag some of these concerns, because we are, we go on the overdrive when applying sanctions. It's very easy for a sovereign state, but can we divorce reality and say that this will not be applicable? Thank you. I hope that question made sense, really. Thank you.
The next, please.
My name is Astrid Kaluko. I'm from Atlas Institute in International Affairs in London. So my question is, will conclude some questions that already asked. So as autonomous vessels and AI systems are moving from, let's say, trial in countries like Norway, Japan, China into disputed waters, so this makes the legal question even sharper, let's say, in South China Sea as one of the choke points and critical points in Indo-Pacific, where the disputes already involve ramming, blockades, and even water cannon attacks. So my question is about, if a Coast Guard drone or unmanned vessel with AI were used during a Philippine resupply mission to, let's say, Second Thomas Sol, and it collide with or block another vessel, who should be held responsible under the international law? Is it the flag state, the remote operator, or even the company that built this technology? And second example, if, let's say, Vietnam deployed an AI-driven surveillance drones to monitor its oil bullocks, and thus drones were disabled by another state, would that be seen as a lawful enforcement action or an unlawful use of force? So in the situation like this, how should international law evolve to decide accountability when new technologies are used as tools to gray zone coercion? And how can we make sure that the rules stay uniform, whether in Indo-Pacific, whether in Europe, whether in other worldwide, rather than breaking into rivalry regional systems? Thank you very much.
Yeah, it is 12:49 now. I think, we will listen to the next question also. I am going to close the questions because, time is up. And this one question, second one from you.
Yeah, should I go? Okay.
There are how many questions now? 1, 2, 3, 4, 5, 6. So all the questions can be, taken together and it will be answered by the panel one by one. And with that, we close the panel. Is that right?
Yeah. Should I go?
Yeah.
My question is primarily directed to Captain Khurana. Because of what you said about Mr. Trump signing out of, not being part of UNCLOS as America, and then Trump signing out of the Paris Agreement, right? So my question is, then do you think for the developing economies or other countries, law acts as an impediment? Because as soon as they sign up for this law, any law, so let's say technological law on mass, then on UNCLOS and another agreement on mass, and then they sign up and end up violating it, it makes a justification to go against them. So is it an impediment for the other nations to go for it when there are clear examples of hegemonic institutions and countries not agreeing with those laws?
Okay, then next question.
My questions, I'm Surya from World Maritime University. My questions to Dr. Johansson. Thank you for this illuminating intervention on liability. But from a very ontological level, we attach liability, ergo extension, to culpability only when they're deviating from a set of rules or frameworks. When they're not in place right now, how are we deliberating liability without having rules and regulations? And especially given the fact that these technologies are evolving with rapid velocity. The liability will be changing at a rapid pace as well. We have the no harm principle or harm prevention principle, but that's only at the principle level. We don't have any laws or rules specific. So to say the technology is deviating from this particular rule will only give birth to liability. So what are your thoughts on that? Thank you.
Then next question. From the last.
Good afternoon, everyone. I am Rahul from National Maritime Foundation. So my captain goes to Captain Khurana. Sir, as you have talked about the autonomous warfare system, so as there is one line that warfare saves the technology or technology saves the warfare. So should there be a global ban on this autonomous warfare system? And if it happens, so how it derive the future perspective? Thank you.
Okay. The last question.
Hi, I'm Sonali Mukherjee. I am a maritime lawyer. My question is particularly towards Advocate Rehana. So you mentioned that the Merchant Shipping Act 2025 does address mass in its broader interpretation. Now, having perused the act myself and as a fellow advocate, knacking our brains to interpret the earlier versions to incorporate AI, cyber issues into those acts, I firstly would deeply appreciate the new versions of the act that have been notified this year. Building upon that, I just want to know is DG Shipping, were there talks on integrating all these modern tech issues into these acts in a forward-looking manner? And if so, are we looking at major policies in the future from DG Shipping on AI and cyber tech to be integrated into the shipping industry?
Okay. Now we try to answer this. Captain Khurana, please have a place.
I'll be very short and to the point. The first question on China's gray zone warfare in the South China Sea. Theoretically, yes, the Chinese can use UUVs, even AUVs for attacks against the Filipinos, against the Vietnamese. If they do that, because such, whether they are autonomous or unmanned and not autonomous, they will have the tag of the Chinese state. Therefore, it really doesn't help them, in my view, and that's the reason why they are going in for much more benign kinds of forms of impeding and asserting their claims, such as the Chinese Coast Guard and even the maritime militia. So it's a theoretical question, and if it comes to that, then certainly the Chinese would be responsible as a state. Question number 2, do developing countries face impediments in going in to sign legal conventions, new legal conventions? Yeah, that's always been the case. Of course, this is not, it's not only related only to the emerging technologies. This has been a rule right from the beginning. It's not always the developing countries are at the receiving end. For instance, if you look at UNCLOS, the UNCLOS was fundamentally designed to help the developing countries, isn't it? And that's when the Part 11 of the UNCLOS came, which the Americans did not sign because it was against the commercial interests of the Americans. So it's not always like that, but there's one thing which is important to bear in mind. The interpretation of law by the more powerful countries certainly will act, as you yourself have said, to the detriment of the weaker developing countries, because unfortunately the global system, international system is such that geopolitical power, comprehensive national power, has a big effect on the outcome of how you interpret international law. And you see the case with the Chinese. They have dismissed the Permanent Court of Arbitration's verdict in the South China Sea, which the Philippines had taken them to. And they said, so it just might as right, isn't it? So these are some important issues. The last question is about, you talked about the autonomous maritime systems, use of that. Should we ban autonomous weapon systems? Well, that's a view. One thing is important, technology will have a profound impact on warfare, and you've seen that happening right now in Ukraine when the unmanned systems were used so successfully by the Ukrainians against the Black Sea fleet of the Russians, and it's changed everything. And right a couple of months ago, you saw Operation Sindoor, which India conducted against the Pakistanis, and you saw the use of drones as never before. So this is a very great example. But coming back to your main question, should we ban AMS? I don't think it's going to happen because there are so many technologies, and the Americans, we know that they are not only going for autonomous weapon systems, including surface and underwater, they are going to the extent of designating them as warships, saying that, so what, if the commanding officer, the commissioned commanding officer is not on board, he is ashore, but he still remains the commanding officer. So this is the interpretation of law. I do not think the AMS will be banned, and that there is a great cry all over the world to ban the AMS. But yes, if you go to the lethal autonomous weapon systems, which take a decision to make a lethal attack on somebody somewhere, that is an issue which is being debated today, which I already talked about in my presentation. Thank you.
Mike.
All right, so many interesting questions, not all aimed at me. The few that were general, I lost track. I should have taken notes, but I'll start in a numerical order, going from number 1. The question, if I understood you correctly, was about sanctions against technology, right? So what's the point? Go back to Isaac Asimov. Let me take you there. Technologies should obey. Humans will always be in control, no matter how autonomous the system is. And of course, I have a big problem with considering autonomy and attaching that to a technology, because if you look at the definitions of ISO and all other organizations that have developed common minimum standards and have defined autonomy, or have at least tried to define autonomy, they say that it is capable of operating by itself. But with technology, someone has to at least start the button, right, for it to start. But again, sanctions would not really work in that place. Again, there is no stopping technology. I mean, look at where we are, fourth industrial revolution, and technology has an ubiquitous influence in everyday life. And we are dependent on technology. If I don't have my laptop, I mean, here the Wi-Fi is, okay, I'm not going to comment on that, but I'm going crazy. I need my technology to work, right? So we will use that, but the question is, how constructive is that usage? Maybe we can talk about it during lunch. Also, I'm a little hungry, so my words aren't flowing. The second question, I'll take 2A on autonomous vessels. Well, mass regulations are not fully mature yet. The work is still going at the International Maritime Organization, but the quickest response to your question is it's going to be the shore-based personnel. But again, if you take away autonomy from the vessel and think from a normal ship perspective, the question is it a maritime incident? Is it a maritime casualty? And what does the post-investigation report say? And then you have to go by the context of what happened and attribute liability. But it's the human element, shore-based personnel. Surya, the answer to your question is brief. If you look at the articles that have been authored over the last 10 years on autonomous vehicle, not vessels, vehicle, US, look at Tesla. There have been trials and errors. There has been a fatal injury. There has been a casualty. There, they were not able to attribute the liability to the operator, and that is where they used strict liability, something that I pointed out. In the strict liability, it is a defective product for which you don't have to go through litigation. You don't have to establish causal nexus. Yes, the laws are not there, but again, the words that I use is unleash the full potential of what already exists, and that's what the courts are doing. But I don't think any severe penalty was given, because it's a technology and it's driving autonomously, again, a word that I'm really not familiar with, but I hope that answers your question. Thank you.
Thank you for the question. Answering to your questions, I guess this is a forward-looking law. It has come through a lot of extensive exercise from 2016 to 25. So it was envisioned that it would incorporate and have flexibility to incorporate forward AI and mass-related terminologies. Second question was connected whether there would be a major policy change. I think we are already there. The policies are coming in a way that we have already guidelines for autonomous vessel development by the Indian Registrar of Shipping, which is being supported under the DG Shipping existing policy with the Shipbuilding Development SBFA 2.0. So I think we are already there. Thank you.
Thank you very much, because we are late for lunch. 2 minutes or 3 minutes we exceeded actually the time allotted. And thank you very much for all the panelists.
Thank you, sir. We would like to invite Professor Dr. Shantakumar, Provost, Gujarat Maritime University, and Director, Gujarat National Law University, to felicitate our esteemed dignitaries. Firstly, our moderator, Dr. Manimuthan Gandhi.